Welcome everybody. My name is Maurice Collins, one of the organisers of this event. As you well know, the title of this conference is Back Up Our Rights by Knowing the Law, and the whole project is supported by Kith and Kids, Disability Law and Pavilion Publications. It's also a commemorative event because on June the 1st, Doreen Collins, one of the starters of Kith and Kid, passed away, and recently Sandra Rosen. So this is dedicated to those two members of Kith and Kids. Kith and Kids was founded 50 years ago, or 51 years ago, and this conference should have happened last year in reality, but due to COVID, of course, it didn't occur. As you well know, Luke, who is presenting our main part of this particular conference, is the Cerebra Professor of Law and Social Justice at the School of Law at Leeds University. His academic research and litigation experience is primarily concerned with the rights of people who experience social exclusion, including disabled people and their carers. He has helped draft and promote a number of parliamentary bills aimed at improving the rights of people experiencing social exclusion. And Luke is also funded by the disabled children's charity Cerebra, and publications emerging from this research collaboration includes reports concerning the accessibility and effectiveness of disabled facilities grants, local authority home to school transport policies, direct payment social care charging, delay and complaints, the social care policies that discriminate against disabled children. And he is also a patron of Disability Law Services. So I'm going to hand over to Luke. We will be coming up at the end of the process. You will put any questions into chats, which we will then relay on directly to Luke. Anyway, I do hope you enjoy the day. The breakaway rooms, which we will explain later on, but Sophie, who is organizing, a big thank you to her, organizing the technological side of this event, will be telling you how to get into your rooms. But I just will quickly remind you of those 4 breakaway rooms. One is the free legal advice service provided by Disability Law. The second is working with local authorities. And in that situation, it's not necessarily working with them, but working with them to understand how we can get the best out of that knowledge. Then we have advocacy case studies, one which is a part of Kith and Kids, one which is private, which is mainly there to deal with our sons and daughters or the people you care for after we pop off. And the last one is intentional communities, where in fact we are studying a particular project at the moment where a village is trying to be closed down, and we are putting up a fight to stop that happening. So at this point, I'm going to pass you over to Luke, a great friend of Kith and Kids. Don't forget to undo yourself, Luke, and off you go.
Thanks very much, Maurice. It's great to be here and really grateful to being invited. And
Luke, you're just on mute.
All right. Okay. I don't know how that's happened. Can you hear me now, please? And can you see that first slide, learning disability, back up your rights by knowing the law?
Yes, all good.
Yeah, great. Okay. What I'm going to do is therefore speak for about half an hour. If you have questions, comments, issues you want to raise, can you put them in the chat function, as Maurice says, and then Maurice or colleague Paul will relay these. I won't be able to see them, and then we'll Maurice and Paul will probably pick out some and we can discuss that for the remainder. I think the idea is that I finish at about 2 to 3, and if that's wrong, Sophie or Maurice tell me. But as I say, I'll only try and speak for half an hour. So Maurice and I go back quite a long time, and I've always been an enormous admirer of what Kith and Kids have done. And it's great to have the other partners involved in the session today. I do a newsletter every sort of randomly often. And it was one of these, I think, that I sent to Morris that he suggested that I do a talk and basically rake through a disparate, disjointed list of stuff in the newsletter, which I'm going to do now. At the bottom of that slide on the right-hand side, you see my website, and you can sign up there for newsletters and all that jazz. What I wanted to do to start with, however, was to talk about basic problem solving, because one of the issues in social care is that people tend to have clusters of problems. They don't have one problem, they have multiple problems that come along. And as soon as one problem is solved, there's another one fills its space. And so all of us really involved in this area have got to develop sort of problem solving techniques to just stay relatively sane. And one of the publications we've done with Cerebra is a guide to just solving problems, which, you know, lawyers don't normally talk about much. They like creating problems more than solving them. And this is something that can be downloaded from the website. And I just wanted to talk about some basic techniques, and then I'm going to look at rake through some legal issues. What we tend to do when we're trying to resolve a problem within the sort of organizations I work with, within the advice groups I work with, is to often start from the point of view of saying, well, this is a difficult problem. What would a reasonable public body do when it's faced with this problem? And I think that's something you can rhetorically ask public bodies, local authorities, NH bodies, if they're not acting very reasonably, to say, look, I'm not saying this is an easy issue, but a reasonable public body would not do what you've done. They would do this, that, and the other. And they wouldn't effectively stand on their heads. They would act rationally. So reasonable public bodies know and obey the law. Now, all too often that's not true. Many frontline workers don't know the law, and so they are not clear whether they're obeying it or not. Public bodies act rationally. They look at the evidence. They don't adopt sort of inflexible approaches. Flexibility is particularly important at the moment, where we've seen very many authorities becoming overly rigid, and particularly the NHS, in the way that they care plan and support, and particularly during COVID, when we've been screaming out for flexibility, but we get rigidity instead. Public bodies do the best that they can do. They can't necessarily wave a magic wand and solve everything. But often what we're saying is, in this situation, a reasonable public body would, for instance, develop a plan so that within a reasonable period of time this problem is solved. They would contact outside experts. They would do this, that, and the other. And in cases of urgency, public bodies put in support first and assess later. And when there's an inter-authority dispute between, say, education and social care, or social care and the NHS, they grasp the nettle. The public body, one of them, grasps the nettle, secures the support before having some sort of complex negotiation with the others. These are such commonly occurring problems that we write about them quite a lot in the problem solving guide. Useful things that I think people who are involved in these disputes, acting for families, can do is, well, the first thing you can do if you have a disabled child or you're a disabled person is to get support. I think that's by far the most useful. And that's not technical support, it's just support from, almost emotional support from a small independent user-led support group, which is what we're doing quite a lot of work with at the moment. And I suppose Kith and Kids is the paradigm example of that sort of organization. Morris probably knows far more law than I do, but he knows lots of lawyers anyway. So these are groups that know which levers to pull, who to give a ring to, but they share understanding of the problems of disabled people and carers. You do need to know your rights, but as I say, that's not the greatest problem. On websites like mine and with support groups, you can normally find somebody who will be able to tell you what the law is on that. Often it's very useful to get what you're saying on somebody else's letterhead. Very often we're acting for parents who write brilliant letters to local authorities explaining exactly what the problem is, and the local authority ignores it. But as soon as that exactly the same letter is put on a letterhead from a head teacher or from a lawyer or from a university department or from a occupational therapist, suddenly it's read. It's academic concept of credentialism. So getting it on somebody else's letterhead, what you're saying, is very useful. Get everything in writing, even if it's said on a phone. Immediately send an email and say, on the phone, you said this, you said that. I may have misheard what you said, but unless you tell me I'm wrong, this is what I think you said. Record everything, get every date down. Lead on the facts. Don't rush into the law. Just say, this is an appalling fact case. If this isn't provided, if that support isn't provided, then this serious issue will occur. Refer to what a public body would do in a situation like that. And give, we talk about this in the guide as well, sometimes drop in a little snippet of the law, refer to an ombudsman's decision or something like that. But don't lead on that. Just put it in as a footnote or in brackets. So you're really communicating to the public body that, you know, if you want to go to the legal stuff, we know what we're talking about. We don't particularly want to do that. We just want to resolve this problem. But it's a bit like we often say, showing the instruments of torture. If you want to do that, we can do that. And there are phrases that you can use a lot. Magic words. I think Morris is particularly keen on fettering of discretion, and that's where a local authority is acting in an inflexible way. It's sticking to rigid rules, not being personalized. That's something that is a serious offense these days. Not saying that this is wrong, but saying it's maladministration. Maladministration is a magic word that means that you know that you can go to the ombudsman, and spell checkers sort out how to spell that, so you don't have to worry about that. Sometimes saying something engages the Equality Act, or I'm advised that it engages the Equality Act, it's discrimination, is a powerful thing to say, because it's quite a complex piece of law. And I'm going to be talking about some research we're doing at the moment, which we think clearly engages the Human Rights Act 1998. So those are phrases that are quite useful to say in letters. One I like a lot, it just is a sweet turn of phrase. The Ombudsman has often really pointed out to rigid procedures which are followed simply to maintain the purity of the accounting rules of a local authority, even if it sacrifices an individual's well-being. And that's quite a nice phrase to use. Anyway, that's rushed through all of those tips and when you're using techniques to try and resolve problems. And in the back of the toolkit, we've got lots of template letters that use those phrases. So I'm going to rake through some key issues that were in the newsletter, just to highlight some points that seem to be cropping up a lot. These aren't necessarily recent issues, and some of the cases I'm going to look at are not new. So I'm going to start with adults in need, disabled, elderly, ill people, people with learning disabilities who are 18 or over. And a major problem at the moment is cutbacks, people being reviewed annually and then their care plan being cut back, their support arrangements being cut back, even though they haven't got any their needs haven't changed in any way. So this was a case concerning an adult who'd be receiving direct payments to cover her eligible needs. And on review, the local authority cut the package, although nothing had changed. They cut it by 7 hours a week. And they said, well, that's because we effectively don't do support for nutrition, eating and feeding anymore, or for maintaining a habitable home, because you get disability living allowance, and that's what disability allowance is there for. It's not for us to be subsidizing that. Now that's complete nonsense. And I'm glad to say the Ombudsman said that. The Ombudsman said the Care Act places duty on councils to assess a need, to decide what the eligible needs are, and where there are eligible needs, they must be met. And there's nothing in the Care Act or the statutory guidance which allows a person to require, allows the council to require a person to use their benefits in that way. You can be charged, and I'll look at charging at the end of this session, but you can't, the mere existence of an income, a benefit, is completely irrelevant to your social care needs, but it's happening a lot. A lot of frontline social workers are saying, well, that's what your DLA is for. It's not. They're not being naughty, they just don't know the law often. And in a way, a similar point, a number of local authorities are choosing to pick and choose between which of the needs they will meet and which they won't. The Care Act has a list of 10 outcomes that would make you eligible. For instance, accessing the bathroom, keeping clean, feeding yourself, being safe within your home, and so on. And one authority, and I think a number of authorities, but the one that the Ombudsman picked on, was saying that they won't fund support to keep your house clean, and that disabled people should find the money themselves to do that. Well, maintaining a habitable home is one of the outcomes on this list in the eligibility criteria. And as the Ombudsman quite rightly said, in this case, the council appears to have decided that some needs are more important than others. This is contrary to the Care Act. Legally, all those needs are the same, whether it is to feed yourself or access the bathroom, or to dress yourself or to keep your house clean. They are all exactly the same weight. And it's not for councils to pick and choose which of those needs they meet. They're all of the same importance. Carers assessments, a lot of complaints about these, and a recurring theme, again, sticking with the point I've made about people being reassessed and having their care packages cut. Very often, if a care package is cut, the disabled person, because their needs haven't changed, because they are having the same needs, they're going to get less support from the local authority, which inevitably means that unpaid carers will have to take up the slack. And what the Ombudsman has said, as the law says, is that carers don't have to provide care. We abolished the duty on family carers to care in 1948. And so if as a result of a cut by a local authority, somebody will need additional care from a carer, then they've got to make sure that they have discussed that with the carer. And it will be unlawful for, without assessing the carer, but explicitly clarifying and recording whether she or he is willing and able to provide that additional care. So the carer would have to say, yeah, you're going to cut my son's care, my daughter's care, and I'm absolutely thrilled to then put in another 10 hours providing that signed, dated love and kisses, basically. So a number of cases on that. Local authorities seem to be doing it nevertheless, but it's important to realize that any cut to a care package that has an impact on carers would need to be recorded in writing that the carer is willing to put up with that. Morris and I were talking about this issue a few weeks ago, and I think it's going to be one of the case studies that you're discussing after 3. But it's this idea about dogma. I mean, I'm old now, and I have lived through a whole series of fads in social care. And, you know, obviously many of those fads are useful, they're good things. The move away from the medical model to the social model and so on. But these are, in a way, theories, and they can inform the way we behave and what is generally good or what is generally not good. But they are not a universal sort of solution to individual problems. And a really important case, it's not a recent case, but it's one that we were discussing the other day that we need to remind ourselves about, is this judgment of Lord Justice now, and Jackson, against Hertfordshire and Ealing. And it concerned a learning disabled adult. He had autism and very fixed feelings on certain things, who had lived for many years in a home farm type community setting. And those settings, you know, one would say in terms of dogma, are not in fashion anymore, just like day centres are not in fashion anymore. And so the local authority decided that it was going to bring him back from his rural setting and put him in the middle of Ealing in supported living. And the judge looked at this and wanted to know whether they'd done a best interest assessment. And there wasn't one outcome that supported this as being in his best interests. And what he said, I think, is something that we should all almost learn off by heart, is that the reality was that community living did not hold benefits for him, and that facing up to these realities does not in any way diminish or demean him, but values and respects him for who he is. Guideline policies can't be treated as universal solutions, nor should initiatives designed to personalize care or promote choice be applied to the opposite effect. These residents are not an anomaly simply because they're among the few remaining recipients of this style of social care. They might better be seen as a good example of the kind of personal planning that lies at the heart of the philosophy of care in the community. Hugely important and very wise words from an excellent judge. So we've looked at assessments and carers and disabled adults. Hopefully all of you are well aware that once somebody is assessed as having an eligible need, that need has got to be met. In the Care Act and the Chronically Sick and Disabled Persons Act for adults and children make it clear that this is non-resource dependent. The fact that a local authority is short of money, which they are, is at law utterly irrelevant. The need must be met. And so if the assessment identifies a need for, say, 10 hours of personal care a week, then that's got to be met precisely, not 9 hours, not 9.5 hours. It's got to be met. You can't trim needs in the face of resource shortages. If the government wants to change the law, they can bring an act and put it through Parliament. But until they do that, the law says these needs must be met. And it follows that there can't therefore be maximum packages. The need has got to be met. So sometimes you come across situations where people say, well, you can get, I don't know, 12 hours respite care in this authority a year or a month or whatever. And the answer is that's nonsense, because needs have got to be met. And whatever the need for respite care is, it would have to be met. You can't have arbitrary, you can't have maximums. The work we're doing at the moment, which I'm going to spend about 5 minutes on or something, is about disabled children's needs. And it's something I'm pretty fired up about at the moment. So I wanted to share this because we're going to be publishing our research on this this month in June. And we're at the moment going to call this research report Institutionalizing Parent Blame. We've done a survey of parent-led carer groups, parents of disabled children, a big survey of parent carer-led groups. And also we've analysed the relevant policies of all English social services authority, children's services authorities. And really what we're saying is that the guidance that's been issued, which is Working Together 2018, is just not fit for purpose. In fact, it's verging on being unlawful because it's exclusively focused on, almost exclusively focused on child protection. There's no separate guidance for disabled children. There used to be until 2013, but it has been repealed. And so what we're getting is that very many disabled children and their families are being assessed in exactly the same way by exactly the same social workers as children who are thought to be neglected or abused. And so you really have two routes. In theory, you should have two routes to the assessment of children in need. But in theory, disabled children should go down the route on the right of this slide. They should be assessed by somebody who's got disability expertise, a social worker who has expertise in the needs of disabled children and the impact they have on families. They should be assessed against a menu of legal rights to services reserved for disabled children under the Chronically Sick and Disabled Act or the Children's Act. And a support plan should be put in place to provide those services, and that should have annual reviews. So these are long-term plans, and if the care and support plan doesn't work properly, then obviously it would need to be adjusted and increased, and that would carry on until you get to the stage when the child is entering the transitional phase into adulthood and there would be a transitional plan prepared. That is not happening except in the most unusual situations. What is happening today is that all children in need, and disabled children are one variety of those legally, are being pushed down the children in need early help route. They then get assessed for time-limited short-term inputs, and almost invariably, because the vast majority of children going down that route are children suspected of abuse or neglect, the default position is to correct poor parenting and probably to send the parent on a parenting class. If this fails, then safeguarding is considered, and if the safeguarding considerations don't work, then the child could become a looked after child. And this massive increase we've seen in looked after children in the last 10 years. So you're treating disabled children and their parents as if they are children who are being neglected or abused. And the surveys that we've done have found that many parents of disabled children who ask the local authority for help, so there's no suspicion at all, and no evidence whatsoever of neglect or abuse, are then getting a response that they feel is humiliating and blaming them. Social workers who turn up with little or no notice, insisting on speaking to the children alone, insisting on seeing the children's bedroom, handing them forms which are safeguarding forms, focusing on parents' inadequacies and telling them that they need to go on parenting classes, when what they need is the sort of support that is listed in the legislation under the Chronically Sick and Disabled Persons Act. And our findings are not unique. And earlier this year, and it was very welcome, the Department of the Health itself published a document that confirms this. The document says that even where the sole reason for contact with children's social care was because the social care needs of an autistic child. There was a tendency to use social work assessment as an opportunity to judge parenting capacity through a child protection lens rather than a lens of social care. This has long been a complaint of families caring for disabled children. We're also particularly troubled by reports received from families who have been brought into the child protection process because of the disagreement with practitioners about their child's behaviour could best be managed within the home setting. This is a repeated concern that we hear from parents and carers outside this study. Now, that is an official report by the Chief Social Worker for Adults and the Chief Social Worker for Children. And this is a major problem. So we're going to launch this report later this month, and the BBC is doing the Freedom of Information studies for us, and there will be media coverage on this, including from the BBC. And that approach is something that contravenes human rights. Coming into people's homes, inspecting their bedrooms, and talking to their children alone is a serious interference with the right to respect for your private and family life and home. And the fact that parents agree is no excuse, because when they're confronted by a social worker who is waving a safeguarding form at them, as the evidence that we've got shows that they feel they have little or no choice over the matter. And failing to treat people who are different, so treating disabled children the same as neglected children, is itself discrimination under Article 14 of the European Convention. And there's a famous Greek case on that point. Now I'm going to, I've got about 5 more minutes and then we'll open up for discussion. Parent carers assessments, this is a major issue. The Children Act was amended in 2015 to have a duty to assess parent carers. This is not happening across the board. And although the Act says you can combine assessments, many authorities are always saying that they will always do the disabled child's assessment and the parents' carers assessment at the same time. That's what we would call a fettering of a discretion. There's a power to combine, but local authorities are saying we will always combine, and that's unlawful. But even if the assessments are combined, there must be a distinct analysis of what the parents' needs are, and looking at their right to work, to undergo further education, training and leisure needs. And there must be a separate document given to the parents that actually details that. And there must be no assumption that parent carers are willing or able to provide or continue to provide care. All of those things are being, it seems to me, in general, ignored by Children's Services departments. It's a strong point, but all the evidence I'm seeing from our surveys and an analysis of their protocols suggests this to be the case. There's an excellent ombudsman's case where the inappropriateness of this behavior is spelled out with precision, and the right of parents to work and the legal obligation of local authorities not assuming that parent carers are willing or able to provide or continue to provide care is spelled out. A lot of problems with direct payments. I'm going to sort of lengthen my stride and finish now, but direct payments should be, it was campaigned for by disabled people as a way of providing choice and control. And yet it is becoming a bit of a nightmare as local authorities become more restrictive and very, very directive about what you can and can't do. Local authorities trying to insist on prepayment cards, which the statutory guidance has very clearly said they can't. And what we've seen, particularly during COVID, is that not allowing to carry surpluses over from 1 week to a next, let alone 1 month to a next, even though, as you'll see on this slide, there's guidance from NICE saying that that's the whole point about flexibility. And in fact, not being able to carry over surpluses from one period to another is effectively, one would use that phrase, being done because it would interfere with the purity of local authorities' accounting procedures. And so those fixed accounting procedures trump personalized plans, choice, flexibility, and so on. Charging is a huge problem for disabled adults. And I suppose it's the wrong thing for me to finish on because it is fairly bleak. Although the law doesn't insist that people charge, there's a power, not a duty. And although local authorities have the right to waive the charges, the actual procedure for assessing the charges, which is an assessment process, is pretty rigid. And the only wiggle room we're seeing at the moment is the ability to reduce the charge by offsetting some disability-related expenditure. And although the Ombudsman is quite good at ensuring that disability-related expenditure is deducted from the calculation, the Ombudsman's office is, in my view, really disappointing in not then standing back and saying, is it actually practicable for the individual to pay these very high charges that are being levied on some of the poorest and disabled people in the UK. I think charging disabled adults for care is shocking, just as it is to charge disabled adults or anybody for healthcare. So that's where I'm going to finish. I just wanted to flag up some resources. If you go to my web page, I've got a resources tab there with lots of commonly occurring problems and suggested solutions. If you go to the publications tab, then you get the publications, the number of which I referred to. And if you scroll down, you can normally find one. So there's one there on carers' rights. And if you click on that hyperlink, you'll download a book, which is 100 or so pages long, which is free to download. You can do the same with the toolkit and also the Disabled Children's Guide. That's 600 or 700 pages long. I write it with a really famous barrister, Steve Broach. But that's free to download as well. The Council for Disabled Children have paid for that. And then there's a couple of books that aren't free to download. Big beastly book on adult social care, over 1,000 pages, but it's got the wicked detail. And my most recent book, which is about small independent user-led support groups and these clusters of problems. And it's mercifully short and relatively cheap. So rush through that. I hope it's been some help, and it's being recorded, so you can slow it down in the future, I hope. So that's good. Did that slide run? Pardon?
The one of the books, do you mean?
Yeah, no, just suddenly it just said new share, and I just, anyway, I'll go out of that. That's me finished. So we can have some questions. I'm trying to get out of this slide now. Oh, I see. Stop share.
Ah, you're there in your full beauty, Luke.
Sorry
anyway,
for rushing through that, colleague. There you go.
I think that just for everybody's been asking, this is being videoed, if we agreed at the very beginning, and I believe Sophie will mention it later on. Will let you know about how you can obtain the video. So don't worry about seeing what actually we've seen so far. Now, Paul's going to see if there's any ones that he's come up with from questions.
Okay, yeah, hi Luke. So I'm not sure if this was a question, or don't need to tell me. This is a question or a comment, but someone asked, why is credentialism so important, and why is it not challenged?
We do it all the time, don't we? It's I'm clever because I've got a certificate. In The Wizard of Oz, you know, the straw man hadn't got a brain, but he gave him a certificate and then he was clever. I mean, it's a deep psychological issue that if you've got, something on your wall saying, you're a physician or something, you're deemed to be clever. Nobody looks at you for what you are. So it isn't just to do with the way disabled people or carers are behaved. We do it as a society, but it is extraordinary from our research. We have very often had brilliant letters from families. I said this. For example, school transport, where the local authority is refusing to pay for school transport for a disabled child that clearly needs it. The parents write this brilliant letter with photographs and maps and things like that. And the answer is no. We put it on Leeds University letterhead and they say yes. And it's exactly the same letter. And it's human nature. Once you hear somebody is a doctor or they're this, you treat them differently. It's psychology, isn't it? So we should challenge it, but it's all about prejudice and stereotyping. So you have to play the game. Get it on Hogwarts letterhead or something,
Thank you.
Okay, I had a question from Anne, who says, the recent judicial review in Norfolk held that people in community have a right to peaceful enjoyment of possessions. How can I help my son in residential care to the same rights? £24 a week does not allow a young person to enjoy life without help from relatives. I'd like to see the Norfolk ruling apply to those in residential care, but where do you start?
Yeah, I mean, charging is a really knotty problem, and it's just shocking. And of course, the idea that a disabled young person in social care can live independently in terms of accessing those sort of activities on 24 odd quid a week is terrible. I mean, in theory, there should be a judicial review about that, because the personal expense allowance, which is £24 or whatever you've just quoted, is the minimum you should be left with if you go into a residential placement. You can increase it, and I have, on behalf of people, said, well, actually this person needs to go to church once a week and they need to get a taxi and they need to do these things, and therefore you've got to raise the £24 to £50 a week or what have you. There is a discretion to do that. And if a local authority refuses to increase the personal expense allowance, you could go to court and say, in this particular case, no reasonable public body could have come to that decision. And you could argue that this is frustrating the rights of this person to live independently under Article 19 of the UN Convention on the Rights of Persons with Disabilities. And you could do all of these things. You won't get anywhere with the Ombudsman, because the Ombudsman just doesn't seem to get that at all. You could perhaps go to a judge, but judges have no idea what, £24 is a tip, isn't it? I mean, it's a bit about my more recent book, really, is that you're trying to explain to somebody who's lived with advantage what it's like to have these appallingly low sums of money. If you get the right judge, you might win that. But each of these cases would have to be treated on their merits, rather than having a class action that says that it is just a disgrace to force people in residential care to abject poverty, basically, that to deny them all the activities. So there is a possibility of taking a judicial review, but this is wedded in legislation, and ultimately the courts will say, well, you get what you vote for.
Okay, thank you. All right, so we have another question from Jane. Can you clarify how we challenge the unmet needs mantra that's so popular for adults with autism and learning disabilities? Local authorities use this term as an answer in itself, rather than trying to seek to meet the needs.
Yeah, I mean, local authorities have got to meet needs, and many of these needs And so at law, an unmet need is something that isn't an eligible need. It isn't one of these 10 outcomes, which include accessing the community, which include independent living issues, which include transport. So those are situations where the local authorities said, this is something that you won't suffer significant harm if we don't fund it, if we don't provide it. So I'm not really, I think the best way of dealing with that is to get it met out, to argue that it isn't a need that doesn't have to be met, it's a need that has to be met. It's an eligible need. If it's an ineligible need, that's normally at law what we mean by unmet need. It's a need that you say, and we can see that it's important to you, but actually it's not eligible because it's not sufficiently important. So you've got to really up it to become an important need. In any society, there are going to be people whose needs are not going to get public expenditure for. I mean, we do it in the health service. We do it all over the place, that people who will be asking for things and the state will say, I'm sorry, this isn't sufficiently important for us to invest public money in to pay for. And what I suppose my response would be, especially after 10 years of austerity and COVID, is that you have to reframe it as not an ineligible need, but as an eligible need, if that makes sense.
Okay. Okay, so we have another question here from someone. What do families do when the local authority keep trying to put our young person to go wherever is the least expensive and most convenient for them for respite, rather than the child's best interests?
Yeah, I mean, what you have to do, and Kith and Kids is sort of the experts on this, is you have to get an assessment which spells out with precision what is needed. So it's not a question the child needs respite. That you'd have to say the child needs respite in a centre that has got staff with the expertise to deal with people with sensory difficulties or with these particular difficulties, that it's got to be within a short distance because it's got to be in these. So you need to describe what is needed and explain why, if that isn't met, it won't work. It won't give you the break that you need, because you'll be worrying all the time about whether the child is going to, how well they are. Because respite is a service to give the parents a break. And if they are forever looking at their phone and worried because they don't trust the service, or if there's evidence that the service has failed in the past, or it doesn't have the particular skills that your child needs, or it's not available when you need your break, you have to book it, 6 weeks, 6 months in advance. Those are all reasons why it doesn't meet your needs. So you've got to say, my need is for this. I need to be able to book it 2 weeks in advance. I need it on the weekend. It needs to have these skills. And then you can then turn around to the local authority and say, what you're offering doesn't meet the eligible need, because you've defined your need with precision.
Anything else? Oh, and Luke, I think we're coming towards the end of the questions, but I just would you expand a little bit about choice and dogma, how that relates within the law? I'm getting one in myself. We've had loads and loads of questions, some of them as long as the actual conference itself, but we have had a lot as such. I can see it's well over 99 plus.
Okay.
So if it's just to expand upon that to some degree, if that's possible.
Yeah, I mean, I hope I haven't caused offence or...
No way.
I mean, classically, it seems to me that dogma is something that a local authority is very good on, especially when it saves them money. That case in Hertfordshire about moving this man from somewhere where he was really settled on a farm, had been there for many years, and put him in supported living in Ealing, in my opinion, was all about money. It was going to be a lot cheaper to put him in Ealing, and therefore that the dogma came in, that this is, you know, this is putting somebody on a leper colony of just disabled people, as it's referred to. And I get that a lot with this, with day centers. You know, day centers may not be great, and they may not have been great, but some of the people that I deal with actually like them. And they're told that they can't have that anymore because it's actually an inappropriate service. But if you have personalization, you should ask people what they want and not tell them that what they want is actually politically inappropriate. So, you know, I can see there's a lots of benefits in independent living and doing this, that, and the other, but some people, everybody's different, aren't they? And some people have become acclimatized to support services. Some people have obsessional behavior sometimes, that this is what they want and they're not going to put up with anything else. And to be told by, you know, and we get that a lot with disabled children, an overnight respite. We don't do overnight respite because it's not appropriate, you know, well, except in a foster placement or something. And the answer is, you can't have these it's just dogma, isn't it? It's just dogma. And you know, got to say, well, actually for Fred it works. That's what Fred wants, and that's what we want. And we won't be happy unless he's happy, and he won't be happy unless you do what, you know, you're telling us is not in fashion anymore.
Okay,
Just got one quick last question. Can you remind people where they can find the 10 eligible needs that you referred to?
Yeah, it's in the toolkit. It's the 10 eligible needs. The 10 eligible needs are in the Care Act eligibility criteria 2014. So if you go to if you Google Care Act regulations, eligibility criteria 2014, you'll get them. And I think paragraph 2 has I think it's 10 eligible needs for disabled people, adults. And paragraph 3 has the 9 eligible needs for carers. They're called outcomes because that's politically nice. You've got to achieve outcomes, but in reality, they're 9 or 10 things you can't do without help. They start, accessing the toilet, keep hygiene, food, dressing, and that's the list. But some of them are very wide, like accessing the community, family and friends, forming relationships and things like that.
Thank you very, very much. That's really great. I have to say, always with these things, you realize how much one needs to know, certainly as a family member, to actually provide what one always wants to provide for one's offspring. It's an amazing arena of issues. I know that the most dog-eared book I ever had was your book on the law. Not that I could understand a lot of it, but it did help me through the time that I had. Anyway, now it comes up to the point where we're going, thank you again. And I'm sure all of us, I mean, if we could all clap, we would. Thank you so much. We really appreciate what you just said. Now, what we're doing is Sophie is going to break us down to our various rooms. And at the end of it, there'll be 10 minutes at the very end where we all come back together again. And each of the rooms, the chair of each room will state how it went and issues that rose within that situation. Now, Sophie, do you want to say a few words if you're there?
Yes, thank you. So I'm going to open up the rooms in a moment. They're called by the 4 names that you should hopefully know by now. You will see, I will open them for you now. You will see a box at the bottom that's now appearing on your screen, which says breakout rooms. It's 4 squares. If you click on that, you will get a pop-up on your screen where you can select the room that you want to join.
Yeah, that's great. One way or another, that's really helpful. Thank you. The idea that the room lasts about 45 minutes and it will be cut at that point. If people can put themselves on mute, that would be extremely helpful. we will, depending on how the room goes, we intend for questions to be put either for Paul or Zena, who's been able to join us. I'll say a little bit more about Zena in a minute, in the chat section, and we will take those questions at the end. There will be, for those of you who've left email addresses, there will be follow-ups, as you've heard, the recordings, the slides and material, and also we intend to follow up with some surveys and some questionnaires to try and fashion some future events that people might be interested in and around the issues to do with, specifically the organising committee tended to be interested in learning disabilities, but there are in a wider group people who are interested in other social care recipients. My name's Ron Brown. You will have seen from the blurb, I'm the Managing Director of HSN Care. We provide residential support to working age adults in the PMLD cohorts. We've been building quite an innovative and creative offer with our local authority partners and parents and families, particularly over recent years. And people can either check me out on LinkedIn or on my email is ron.brown@hsncare.com. We're very fortunate in having two incredibly talented and experienced people to talk to us today. Paul Johnson has got over 30 years experience in a career in health and social care. He's had 15 years as a local authority senior manager. He's, I think, an important fact, and one that Paul's agreed I can share, is that his twin sister had a learning disability and had what some of us would call very high needs. He has a commissioning knowledge and expertise that's really quite deep and wide. His last role was as Assistant Director for Strategic Commissioning with Nottinghamshire County Council. Many of you will know that's a large council. He's been heavily influenced by his involvement with a small user-led charity called Kith and Kins that some of you may know. That's Paul. I'm going to introduce Zena now as well. Then the plan is for Paul to talk to you about working with local authorities, after which Zena, I'll outline her credentials and you'll understand why. We'll be talking to you about best interest decision making, mental capacity and deputyship as it applies to working with local authorities. Zena Bolwig is Director of Macintosh Law. That's a legal practice that specialises in mental capacity and community care. Zena's own specialisms are mental capacity, community care and advocacy. She's regularly instructed by private individuals, advocacy organisations and other social care organisations. She represents individuals who lack capacity and their families. She's seen as an accredited legal representative and is a really, really talented, high-flying person. There's no two ways about it. In 2016, she was recognised as a Rising Star of the Year by the Modern Law Awards, and in 2020, recognised as Next Generation Partner by Legal 500 for her court protection work, and nominated as a leading individual by Chambers UK in 2020. So we only managed to secure her services at the last minute, as she's a very busy person, but we're delighted to have her. I'm going to hand over to Paul, and if you put questions in the chat, we'll go on to Zena and try and wrap up the questions as much as we can to either Paul or Zena, or I might even pick up the other one myself if it's in my space. Thanks very much, Paul. Over to you.
Have you got the slide deck, Ron?
I think that's with Zena.
Am I in charge of that? Bear me one moment. I thought someone else was going to be doing it and then I would be the fallback, but I will fall back right now. Bear me one moment.
We've fallen back, Zena. Thank you
Yeah,
very much.
fall back on me, that's fine. Excuse me, everyone, for the moment's delay. I'm worried that I'm going to share something I shouldn't share on my screen, so I will just do this properly. It's just opening and then I'll have it with you. Can you see the Working with Authorities share screen?
Yep, not in full screen, but
Bear with me a moment.
Yes, we can.
Thank you. Can you now see that in full screen?
I can. And can I click through it, or
I can do that for you. I will be your glamorous assistant.
that would be fine. Okay, if we start with that slide. Good afternoon, everyone. You know, Ron's introduced me, and I am here in a personal capacity. I retired from Nottinghamshire a year ago. What I wanted to do today was actually sort of share some of my reflections on being a strategic commissioner and actually thinking through how we can and did work with parent carers and make that relationship really important. Contextually, I'm very aware, and Luke's presentation as well, is that I'm really speaking from an English perspective. So some of the things I'm going to say are contextual about an English perspective and not Welsh or Scottish, because Luke's presentation also, I think, was you know, not speaking in terms of the Scottish perspective in terms of free social care and the like. So if we go to the next slide, what I'm heading this, my glamorous assistant, next one, thank you. How I really conceptualize it is actually if you've got someone with a learning disability, someone you care for, you're a parent carer, you're someone who uses services, you're likely to be in a long-term relationship with the local authority. So I sort of feel it's sort of akin to what you need to know is know who you are dating. Have that in your mind in terms of, rather than being beware, in that first line I've got is so be aware, instead of being scared and be wary of a local authority, be aware. And by that I mean have your eyes open. If this is a long-term relationship, think who you're dating, be informed, and actually make sure you know who you're dating. Just very, very basic, and I didn't know who the audience was going to be, but what you really need to think is, what is a council? So very, very quickly, there are 343 local authorities, but you do need to remember that only 151 of those are responsible for adult social care. So not all councils are the same when we use that word. It's very much like apples and pears. So again, just very briefly, there's unitary, upper tier, lower tier, metropolitan London boroughs. There's a whole plethora of things that are called councils, have different responsibilities. I won't go into that now. That, you know, clearly wouldn't be relevant. There's a little link there which I think is helpful and does explain the differences. But my tip, and I'm going to go through these in the slides, my tip is actually take time to find out who does what. One of the commonest examples is, I worked in Nottinghamshire. We were an upper tier local authority, but we were not responsible for housing. Nottingham City, unitary authority, they had the whole gambit of social care and housing. And it's important to know that distinction, because you could actually have different issues for different councils. Okay, next slide, please. I seem to be frozen. Does that what someone say? Next slide. Right, oh, can I go to the one before? Yeah. What also is really important to remember is that councils, unlike the National Health Service, are political. I think Luke's touched on some of the politics of what we're here today, but actually you have to remember that councils are political. Elected members have to set legally balanced budgets. they also have to set criteria, and they don't use the word ration, but actually that in effect is what has to happen. We would use the word prioritisation, but they are in the business of making sure the budget that they are given balances. I suppose one of my tips then is actually know who your key councillors are, actually know what their responsibilities are, and do that both for the governing group, the group that's running the council, but also the opposition, because every 4 years it may change, and certainly after every election some key councillors will change, and actually find out which councillors are the ones that are most important for you, whether it's childcare, adults care services, health and wellbeing board, and find out a little bit about them. In my experience, a lot of councillors actually have some direct experience and personal experience in disability and those matters, and actually are probably more approachable than you think. Next one, thank you. One of the other misconceptions is that adult services are generally not free. Luke mentioned that. Yes, adult services, there are contributions, there are charges, there are contributions. That is a requirement. I think it's maybe only one authority that doesn't choose to put in charging for its community care services. So adult services aren't free. You will be asked for a contribution, and that is individually assessed. So my top tip is know your council's rules, because Lincolnshire's rules will be different to Nottinghamshire's, to Dorset's, to West Sussex. So you need to know your own council's rules. Moving on. NHS services are mostly free. That's why sometimes we get a bit of thing, but it's not always. And this can cause confusion. So there's certain services that actually people may be charged for. Also, if you've got a care package, it may be that health are paying some and the local authority are paying some, or maybe education are paying some. It's really important. My tip is actually check on who is paying for what. Often you have a hybrid, a range of commissioners, different people paying for things. Check on who is paying for which bit of that service. Next one. Obviously, the whole of this session has really been about the law, and I suppose I'm just echoing what Luke said. Is in my experience, this is my tips: is know your basics. So respond to what Luke's, the challenge he's put forward, and never be afraid to ask on the basis of what something is being done or is being provided. So that social worker or that social care worker or that healthcare worker or that manager, that person that sectioned your son or daughter or whatever, you shouldn't be afraid to ask on what basis have you undertaken this, or have you actually provided or not provided this. And I think Luke made a mention of this as well. My tip, and I would say, is make a note of this for reference. It's easy to forget. There is a lot of law out there. There's a lot of jargon. And at reviews or key decision points or any meetings you go, always record this. Just remind yourself, even if it's a regular standard review, just remind yourself what is the legislation, what is the law that actually is being utilised at this point. It's always good to refresh. And things change as well. Next one, please. Partnership with the local authority. A lot of people, Maish mentioned right at the beginning, Maurice mentioned about a fight, and it felt like there was a bit of challenge there, and it probably doesn't feel like a partnership of equals. But I suppose I'd throw the challenge down to sort of maybe let people think about this. Yes, the control of resources, does rest with the councils. Yes, they make the budgets, they've got the budgets, but you, as a person using the services, or maybe as a carer as well, but you are contributing to the care packages. You are financially contributing to the care package. Plus, you have that precious resource of lived experience. And good councils, reasonable councils, they value this, and actually they want to co-produce. They want to consider the offer that they're doing. So help them change that offer. See your experience as being a contribution, and that's what you bring to the partnership. So I know it's difficult, and I've got a lot of sympathy with what Luke said around about charging and contributions and people in poverty, and it is a wider political issue, that in terms of actually whether social care should be free or not. But whatever, what I would advise is see your payments that you make more as a contribution and use this to your advantage. So use this as I'm a participant, I'm helping purchase this, I'm contributing to this care package. The other thing I would advise as well is, as parent carers, be respectful that maybe your rights may be more limited than you expect. And I think that's sometimes that I've seen in my experience where conflict has risen, where actually parents believe and feel that they have the rights and they're entitled to advocate for those rights, but actually in many cases it is more complex than that, and maybe what rights they think they have are more limited. So one of my tips that I'm reinforcing as well, see yourself wherever possible as a key partner, and my advice is to offer constructive criticism and appreciation. I think when you're doing person-centered planning, one of the things they talk about is appreciative inquiry, asking questions in an appreciative way that actually understand and show that you understand the dilemma. And I think that's what Luke said right at the very beginning in terms of basic problem solving. Actually come with that approach and attitude, and I think there'll be less clashes. Moving on. One of the things that checking council's performance, again, councils do look at themselves, but actually there's others that check on the performance and workings of councils, and Care Quality Commission is that body. That is what they are, what they're designed to do. So they do reach out to people to help regulate councils, and they need people to assist them in that and assist in the quality assurance. So there is a role there. So I would say my suggestion, my top tip again, is see the Care Quality Commission as allies and offer to help where you can. They do quality assurance surveys, they ask for representation, they have questionnaires, they have all manner of ways to try and reach out. So try and see them as allies, and that can have some benefit. And finally, my final slide for people is just in terms of my very brief reflections on strategic commissioning, because that's where I largely came from, is that all of those 151 councils will have commissioning strategies. Some of those commissioning strategies will be joint with the NHS, some may be with other agencies, with housing, with other partners, and many will be in the council plan. These commissioning strategies, these plans are very useful documents. They give you that information about what the priorities are, what funding is available, and as well as how the local authority is managing the market, which is another one of its statutory responsibilities. So hopefully they're not dry documents. I've tried to always make my commissioning strategies, you know, as much co-produce or have people who use services advise and give, you know, comment and hopefully drive some of them as well, and actually make them accessible. So again, one of my tips is, and my final tip is, find out what your local council's commissioning plan is, so that you can hold councillors and officers to account, because that is the plans that they should be enacting. Thank you. So I'm going to wrap it up there and let Zena carry the baton over. And as Ron said, I'm more than happy to take questions.
I can't hear her.
Same here.
No. Mhm.
I
Right,
can't hear,
you,
I
Zena.
can't hear her either.
Oh, one moment.
Oh, can now, I think.
Can you hear me now, everybody?
Yeah.
Oh, I was saying all the wonderful stuff that you've missed. Okay, so what I was trying to say is that Ron gave me a rather enthusiastic introduction, which has set me up for a bit of a fall. But the long and short of it is that I am a legal aid lawyer. I work on my firm. We practice only for those who have disabilities or their family members representing them. My particular practice is probably about 90% in the court of protection and 10% in community care sort of proceedings elsewhere, but largely relating to young adults or old adults who lack capacity to make decisions for themselves. So that's my background. I'm very conscious that there are lots of questions that have popped up while I was being the glamorous assistant for the slideshow. We will deal with those in turn, if that's okay, once I've finished having a quick talk to you all. And if I've missed anything at the end, I've got no problem with you turning on your mic to ask it out loud. I was dropped in late in the game to this one, and it was thought that it would be complementary for what I want to say to mix with Paul's talk, because Paul's been explaining how it can be really beneficial for family members and those who are in need of services to work collaboratively with the funders and service providers. I couldn't agree more. I think it's really important. The first port of call, and it's sometimes not usual for a lawyer to be saying, try not to fight with them, just have a conversation and fix it. But I think the first port of call for any of us, all we'd ever want is to try and fix a problem without a fight. The issue we face is when those discussions and collaborative discussions don't get the result that we need. And then, you know, sometimes lawyers have to become involved, or sometimes other avenues have to be explored. So what I wanted to talk about is, Paul touched on the fact that there are some occasions where family members or loved ones or carers of a vulnerable person or someone who requires services feel as if they need to be the voice for that person, and what they say should go, and that their involvement is sometimes, their view of their involvement is sometimes higher than what it's thought of by the local authority side. So you might be making suggestions and putting forward powerful arguments for your loved one about what should happen, and the response you're met with, well, you're not that important, your view isn't that, you know, it's not as important as you think it is, it's obviously important. So my angle is slightly different, because I work under the auspices of the Mental Capacity Act largely. So this is my clients being largely over 18. They are adults, they do have their own individuality, their own rights to independence, etc. And there is structured law and regulation that details how other individuals in their lives are consulted and involved. So I think that's a bit of, sometimes that's not always felt to be the case outside of the Court of Protection and the Mental Capacity Act. I should say the Court of Protection is, for those who don't know, a very specialist court that only deals with disputes about, one, whether someone has capacity or not to make any particular decision. So sometimes you've got a local authority saying they can make this decision for themselves, they're saying no, therefore that's it. Family member very concerned about that. Or sometimes you have the opposite situation, local authority saying they lack capacity, we've made a best interest decision, this is what should happen for them, and you are horrified at that decision, for example. Those are the sorts of disputes that I deal with day to day, and they go to the Court of Protection, and the Court of Protection will make findings based on those disputes. So I can answer questions about that later if anybody has any arising. But yes, so the key, I thought what might be useful, because I was hoping not to take up too much of your time talking and hoping to take more of your time taking questions and answering something useful. So just to give you a snapshot of things that you might want to look at, and I'll drop these into the chat in a moment. The main sort of law that you need to know when it comes to someone who is 16 to 18 and above, and transitioning maybe out of children's services into adult services, and you think it's highly likely they're going to be seen to lack capacity to make decisions about, you know, what care they have, where they live, who they have contact with, maybe even going on holiday, lots of, you know, every bit of everybody's life that they might not have the ability to make the decisions on. Then the main bits of law you're looking at are the Mental Capacity Act 2005, and the key sections. It's a large document, but it's an incredibly accessible piece of law. The main sections you're looking at are sections 1, which is the underlying principles, which includes, for example, everybody should be assumed to have capacity unless it's known otherwise. but various other very key principles that also underlie the Mental Capacity Act. Then sections 2, 3 and 4, which deal with 2 and 3 being capacity. How do you assess capacity? How do you know whether someone has capacity or not? And 4 being best interest decision making. How do you go about that tricky process of balancing all the risks and benefits and etc. to make the decision that seems right for the person who can't make the decision for themselves? So those are the key sections of the Act itself that I would definitely recommend if you're in the situation of caring for an adult or soon to be adult who may lack capacity. That's the Act and the sections to look at. And I've just dropped a link into the chat for that. Supporting the Mental Capacity Act is also a code of practice, which again is an incredibly common sense, useful document that isn't too difficult to follow. It's not too legalese, if you like. They are looking at making an amended code, which is being consulted on in the next month or so, although it will probably be some time before that sees the light of day properly. So this code is fundamental at the moment. And again, I will, if I can do this properly, let's see. Yes, I've got it. There you go. There's a link to the code of practice. And the other thing that I just wanted to touch on, because I know that it is often a concern, and I know Ron and Paul had mentioned it before I came on, deputyship and family members wanting to obtain deputyship in order to help them make decisions for their loved ones who lack capacity once they come to majority. That might be, there's 2 types. There's one that's a property and affairs deputyship, which does what it says on the tin. And there's another that's a health and welfare deputyship. So that's where you might want to make decisions about where someone lives, what care they receive, etc., etc. There are deputyships are a thing, I can categorically say, and you'll see in the Mental Capacity Act the relevant sections. I think it's section 16 to 20, although I'd have to double check that. Sorry to say it off the cuff. Deal with how a deputy is appointed, etc. The one thing I wanted to flag about this is there was a case. So there's always been historically a lot of concern, particularly among family members, about the reluctance of the court, particularly as set out in the Code of Practice, to appoint a deputy, a family member as a deputy for a loved one, because of the overarching desire of the Mental Capacity Act to empower an individual who lacks capacity to be able to have independence and make as many decisions as possible on their own. And because of that concern, there were a number of, I think they were actually parents of young adults, so 16, 17-year-olds about to turn 18. And they were very concerned about what was going to happen to their loved one once they just broke over that artificial age barrier to suddenly being 18 and an adult. And they were worried they'd suddenly be left in this sort of hole without services. And they brought a group action in the Court of Protection, or they brought separate proceedings that were then joined, I should say, in the Court of Protection, to ask for guidance from the court on, you know, when they could make these applications and how they would be treated. I can't say that the judgment changed a lot, but I will drop it into the, I hope this is the right link. It might not be a link. I will find the link for you and drop it in. It didn't change a great deal, but what it did do was it said that in the Code of Practice, it said that, you know, it's sort of an exceptional circumstance where you'd be looking at agreeing that someone should be a health and welfare deputy for a family member. And actually what the Vice President of the Court of Protection said was that sort of puts it too high. It's not an exceptional circumstance. As with every decision that is ever made for someone who lacks capacity, it is a decision to be made in the round based on that particular individual circumstances, balancing everything you know about that individual. So I won't go into the detail of it. I will find a link to that case and put it in, but it was Lawson, Mottram and Hopton, which is fun names for the 3 parents that were involved in it. And it was on the 25th of June, 2019, so fairly recently, but I'll send a link in. Yes, and I just wanted to point that out because I know that a lot of parents have questions about that. And if there are any specific questions, you can ask them during the Q&A. So on that very abridged introduction to mental capacity and best interests, I would welcome questions if you need to ask any, and I'm sure Paul or Ron will jump in as needed as well. If you would prefer, I'm happy to go back through the chat and see if there are questions that need answering, but I'm also equally happy for people to put their hands up. I see Alfred has got his hand up. So would you like to go first, Alfred?
I'm just unmuting. Can you hear me now?
I can, yes. Hello.
I'd like to again go back to the point you've made about deputyship.
Yeah.
And in particular, I've got an autistic son of 35, absolutely and clearly has no capacity to make any decisions for himself. 100% in agreement with the deprivation of liberty forms, which describes his situation.
Yep.
And I have been told on a phone call with the deputy people, not really to apply for health and welfare. Now, the reason we're considering it, although he's 35 and we've had no issues and there are no current health issues, there is on the horizon a possibility of potential moves if his current placement should close down.
Okay.
And we want to understand clearly that we can have an input onto that, not just on the basis of best interests, but with effectively I believe, a stronger lever because we are deputies. And I was wondering whether one would just have to accept the court will not agree to deputyships for somebody where there's not an urgent situation, or whether we're just trying to do that on the basis that this may be something that we want in the future.
I understand exactly what you're saying, and yeah, I can see that the issue arises often, and I don't think it's fair to say that you definitely wouldn't get a welfare deputyship in those circumstances. I think from a lawyer's point of view, looking at the law and the case law and what the Act says, you probably shouldn't by letter of the law, because it doesn't really meet the criteria for, you know, lots of ongoing decisions that need to be made for someone over long periods of time. You know, perhaps you've had a long history of disputes with people about what should or shouldn't happen. Those sorts of circumstances are, in my experience, more likely to result in you being appointed as a health and welfare deputy. But what I can say is, although that is my legal answer, like that's what the law would say, is there's never any harm in making the application. You probably have already sourced it out yourself, but there's a very good pack of guidance on the Court of Protection, sort of HMCTS, the Court Service Court of Protection website, on how to make an application for deputyship and what you require. If you don't, then I can quickly Google it while someone else asks a question and put it into the Dropbox for you, into the link for you. One thing I would say is make sure that you're having discussions with the people responsible for making the decisions before you make that application. And it's also very helpful sometimes to get, if they agree and they think, actually, we think this would be a good idea, to get that in writing from them beforehand and include it with your application. There are requirements specifically on who you have to notify when you make an application like that. Just make sure that you do that. And you will need capacity evidence in the form of a COP3, I think they usually use for those applications. You're on mute in case you wanted to say something. You might have done that by choice. And yeah, I mean, I am an avid believer that individuals, even if they lack capacity, deserve the right to have as much independence as they possibly can. And I think having a situation arise in which you are a health and welfare deputy, it's a long-term position. I mean, you're appointed as a health and welfare deputy, you are then in that role, and it's a very all-encompassing role. It impacts on the individual's human rights a great deal. And clearly your son is 35 years old, and you say that happily he hasn't had any massive disputes so far. So one would hope that that would continue. And if you haven't yet had the opportunity to have a look at the Mental Capacity Act, I would have a little look at the best interest section 4, about, you know, the sort of consultation that is required and should be happening. And maybe you want to flag it with the local authority if they are the responsible funder and the provider, if he's in supported living or residential care, now, to say that you're aware of your rights under Section 4, that you do want to be consulted, that you would welcome a best interest meeting as early as possible when any decision is going to be made. And worst case scenario, if you get to a situation where all of a sudden a decision is being made that he should be moved and you completely disagree with it, it will result in a Court of Protection application. But if he is under a DOLS, and therefore I assume in residential care, any challenge to residence or care under a DOLS is non-means tested for him or for the person appointed as his relevant person's representative, known as an RPR. So you wouldn't have to pay for the legal representation. And if you do have concerns, I mean, my details are here, you've seen my face. We deal with this work. So if you wanted to have a quick question to ask whether it's time to do something about it, you're welcome to get in touch, or we can refer you to other people if you'd like someone else. I hope that answers the question.
It really does answer it very well indeed.
Okay.
Thank you for that.
You're very welcome. Good luck with it, Alfred.
Thank you.
I'm going to...
Is Ron filtering? I thought Ron was going to be filtering some
Oh,
comments.
sorry,
Well,
sorry. Please, Ron, I've overstepped my mark.
Dina, I'd expect nothing less.
I'm so
Well
sorry.
done. That's all right. That's all right. Listen, I'll go as quick as I can. I'll try and chivvy people as well. Dina and Paul, we've got a load of questions here, but you'd kind of gone over to hands up there. So it looks like we've got, do you want to take the hands as quickly as you can, Dina, straight away? And then I'll go on to, I've got some in the chat that look like they're directed at Paul, but if you could be to the point.
I will be succinct. Sorry. Apologies, everyone. I've messed up the entire structure of this by jumping in like that.
No problem. No
Can I please have the question as quickly as you can from Ian Penfold?
Yes, thank you, Gina. A couple of things, but basically the power imbalance is shocking, and also the law with regard to mental capacity and so on. Unfortunately, sees us parents, and I have a son of 32 with complex needs and precious little mental capacity. I'm his welfare deputy, thankfully, where we can, because the law says once your child is 18 or older, you only have a right to be consulted over significant decisions. And that very often the authorities use as a kind of a way in which they can sideline us. So that was a general point, and talking about, I mean, I know we're not here talking about healthcare, but it's the same for social care, I think. Even though you've got the right as a deputy, it's still very difficult with a cash-strapped authority or CCG or whatever to actually get what the person needs. And to be honest, in my situation, as with Alfred, we know what's in our son or daughter's best interests because of years of experience. We are lived experts. And it's very, very frustrating and annoying sometimes if we get sidelined because people say, your opinion is not as important as ours.
I can understand that, Ian, and I'm sorry to cut you off. I'm just conscious of time. That I think the security for what your concern is lies in Section 4, and I know that you're saying that whichever local authority you're dealing with perhaps isn't giving that the credence it should. And I'm sorry to say that if you try your very best to work with people and it doesn't work, then the option is to make a complaint, or if it's a serious situation that requires urgent remedy, taking some legal advice or asking for it to be referred to the legal department at the local authority as a breach of the MCA.
Okay, thank you.
Thank you. Eva, if you wouldn't mind.
Thank you, I'll be very brief. Just to let you know that your links are not visible in the chat. And I wonder if you need to change your settings.
My links that I was sending?
Yeah, when you said I'll put the links in the chat and it's not visible.
Yes. I know why. Thank you for telling me that. I will. It's gone as a direct message to someone, which is not helpful, is it? I hope that's helpful now. Thank you for flagging.
Thank you so much. I appreciate that. Thank you.
Bye all. And then we've got Mr. Hughes, Bob Hughes, please.
Thank you very much. Just very briefly, 2 points. My stepson, who's 40, we were about to embark on these things of deputyship and that sort of thing. But then the council changed their arrangements and took the care of LD and autism away from the generalist groups and created a central strategic group. And it was like chalk and cheese. They've now realized that the people they were paying to care for our stepson weren't caring for him at all, quite the reverse. And it really has improved hugely. So I think that's a big thing potentially to lobby for, at least in my experience. And just secondly, very briefly, as a county councillor, I agree with everything that's been said about lobbying county councillors. I'll just add one thing. After 20 years as a lobbyist, now a county councillor, never ask a question of a politician to which the answer has to be no.
Thank you, Bob. I don't know that you need anything from me in response to that. I don't know if Paul's got any comment.
No.
Okay. Carol Beardmore.
Hello. My question is about, I have a daughter who's 36 who has learning disabilities and now a diagnosis of early Alzheimer's. It's that difficult. I've always, we want to maintain her independence for as long as we possibly can, but it's hard to know exactly which route to go down to make sure that, we can make decisions and choices for her as her ability reduces.
I think it's the same point, isn't it, Carol? I appreciate it must be a hard slog trying to get everything that you need for your daughter. But I think the fact of it is, if she is an adult and if she does lack capacity, presuming she does as a result of her diagnoses, then the decision framework under the MCA applies, and it's a matter of keeping the local authority on track for that. Yeah, I'm not sure that I can add anything further really to that. I'm sorry to be unhelpful if that is unhelpful, but have a little look at the links.
Okay, thank you.
Sorry, Ron, I'm conscious that we're being kicked out of this room shortly. And I don't know whether you had specific questions you wanted to look at in the chat before.
I think that there was a couple for Paul, which are basically, one of them is, where would we find the commissioning plan? That's from Christine. Where will we go to get the commissioning plan, Paul?
That will be on each local authority's website. So that should be accessible.
Right. It looks like we're being kicked out of the breakout room. I've made a note of the chat questions and I'll ask Zena and Paul to answer them in the mail out, guys. I'm really sorry we've run out of time.
There we go, recording in progress, or progress. Okay, fab, it's 4 o'clock, so welcome. My name's Tilly Brooke, and I'm part of the management committee of CLASP, and I have a elder sister who is a member of CLASP as well. So this is the breakout room for the advocacy case studies, what happens when families are no longer around. And what we're going to be doing is sharing 2 different methods of providing an advocate service. One being Reserve Power, which is privately funded, and Ralph will be talking to you about that. And the second being CLASP, which is funded by a charity, and Peter and I will talk about different sides of that. We'll kind of run through how they work, the benefits of setting them up and using advocacy services, and I will be giving the perspective of a sibling, as well as bringing in the importance of continuity in both models, such as losing members' parents or getting siblings engaged and acquiring new members as well. So without further ado, I'm going to hand over to Ralph to share his experience of Reserve Power.
Okay, good day to you, everybody. My name is Ralph. I'm a director of Reserve Power, for what that means, because it's not a paid job or anything like that. It's run by families, for families. I'm going to ask a rhetorical question, so please don't shout out your answers. Remember, you're on mute. I won't hear them anyway. Do you believe in insurance, on the concept of insurance, of paying a premium to give you some cover for an event that you hope will never happen? Seems rather strange that you'd be prepared to pay money out to maybe get nothing back, but that's insurance for you. But wouldn't it be great if we could ensure the future well-being of our disabled children? Something I thought about maybe 20 years ago when I'd just finished a rather acrimonious session with my local authority, who were trying to move my daughter from one home to another. One of many acrimonious sessions that I've had. And I really looked for advice. Where is the future for my daughter? Where can I feel comfortable as a parent that when I'm not around to make a case for my daughter, that somebody else would? And I got introduced to Reserve Power by the charity Kitten Kids that you've heard mentioned many occasions today. I got invited to one of their family meetings 10 families sitting around, openly discussing their problems and seeing how they could overcome the problems. And the problems were all different, but really were the same. What's going to happen when we are not here? Who's going to oversee the continuity of the service that our children are getting? Who is responsible for doing that? Well, of course, the local authorities are the ones that are responsible for adult children. They ain't going to do it. So the group of parents decided that because of their because of the way that the local authority had treated them when they were trying to get facilities and get placements for their children, by ignoring them, that they would maybe try a different route, get somebody else to speak for them. So they employed an advocate who worked for 20 hours a month, who started by spending time getting to know the children. He didn't just pick up a file and read it and say, okay, your child needs this, that, and the other. He actually went, he visited the children, he took them out, he befriended them. He got to know them personally and got to understand what it was that they wanted, what it was that they needed. So instead of just looking at the future, what's going to happen when the parents aren't around, the project was split into two. A befriending service now to get to know the kids, followed by planning for the future that was so important to everybody. Gradually, we employed a second advocate because we wanted to, the part-time advocate couldn't give any more hours, but we wanted to increase the level of service we were giving. And that was fine, except as the project progressed, there was growing animosity between the local authority and the advocates and the care providers and the advocates. There was a fear that by employing somebody professional, that we were going to tread on their toes, that we were going to catch them out, that we were going to look at the faults that they had. Far from the truth. Eventually, that animosity disappeared, where the care providers actually found that the advocates were coming in and offering advice not only to help the kids, but to help the staff at the care homes that they were in. The local authorities would listen more to an advocate than they would to a parent, because their attitude was, yeah, you can't be anything other than biased. You're the parent. What do you know? We're the professionals. And that attitude, I'm afraid, was very, very difficult to break down. I'm going to skip a few years and tell you now that we have 3 advocates, all working part-time, giving 50 hours a week of service to 12 families. Each family is therefore getting the equivalent of just over 4 hours of advocates' time each week. It's not a cheap service. It costs £400 per month per family. And it is definitely a non-for-profit organisation that just about covers the cost of running it. The project is managed by the families. Each family has an equal share of responsibility for running the project. We have a management committee, 5 families, but that is not cast in stone. It is a revolving situation where somebody will maybe stay for a year on the management committee, they will come off and another family will take their place. Does it work? Well, certainly on social basis, it works really, really well. The 3 advocates take our children out. We have one advocate that's a mad Chelsea supporter. She takes 3 boys to football every other week. I wouldn't mind, I'm a Tottenham supporter and she could have chosen a different team, but we'll forgive her. Our children get taken out for meals. They get taken out for a walk in the park. The ones that are not in residential care have parties in their own homes, arranged by the advocates. So you can see the social framework that has developed. It helps the advocates to get to know the minutiae of the likes and dislikes of our kids, so that when it comes to them representing our children at reviews, at social service reviews, at medical reviews, they know exactly what to ask for. They know exactly what's appropriate. They know exactly what to say no to. We have a breakdown because I've only looked at the social side so far. If we look at the future planning, I'll give you a breakdown of the 12 families. 4 of the families have both parents still alive. 5 have 1 parent. 1 family has 2 parents. 1 is in a care home herself with dementia, and the other one is 97 and is quite frail. And we have 2 families that have absolutely no parents whatsoever. 1 young lady with no parents has 2 brothers who live in Italy. So really not there to give her much moral support. And the other family has a brother and sister-in-law that they really are not that keen on coming up to the plate. And maybe we are being irrational in expecting siblings to come up to the plate. What right have we got to determine what the sibling wants to do, needs to do, many of whom have their own families and may be living somewhere else? Now, I can only see from how we are operating with the 2 families that have nobody. Yes, it works. Yes, they are getting well represented. Yes, there is a voice for them. One big problem which you touched on, Tilly, is continuity. Continuity at 3 levels. All our advocates work with all of our children. We don't have allocated caseloads. So if one of our advocates decides to leave, then it's not such a big shock. We still have 2, and it gives us time, therefore, to replace that person. So we've got the continuity there of advocacy. We have a problem of age, because our parents are all in their 70s, 80s, even 90s, and they are gradually disappearing. So our plan, which is something that we've implemented over the last couple of years, is to introduce new families under the age of 50, where the parents are under the age of 50, so that they can gradually take over the reins when the rest of us drop off. And the 3rd level, which is something that I never gave any thought to whatsoever, is what happens when our children die. Over the last 3 years, we've lost 2 children. Okay, one was 60, and hardly a child, but I mean, he's still the child in terms of what we have. Again, it's a question of the continuity of the new, younger blood, so that everything goes ahead. And so far, yes, it's worked very well, and I see no reason why it shouldn't continue to work well. The whole point of me talking to you today is because we would like to encourage other people to think in terms of setting up their own groups. We can certainly help people set up their own groups. We won't find the people to make the group, but we can guide you through the setup process. We can possibly even get you some funding. We have an association with one particular charity that is quite amenable to helping new groups with some seed money. So if you ever want to think in terms of getting together, setting up a group, I would happily put you in the right direction.
Thank you. That's great.
Okay.
We're going to leave questions to the very
Questions
very
to afterwards, aren't we?
Yeah, so I'm going to hand over to Peter now, because I'm aware we've only got 45 minutes, so if we can leave as much time as possible for everyone to talk as well. Thank you.
Am I talking about the funding for CLASP or CLASP itself there?
I think a bit in its entirety. Go for it.
Okay. CLASP is an acronym. You've probably seen from my, if I turn off my video, it's KLASP. It actually stands for Kith and Kids. That's the charity that Mace was referring to earlier. It's their Lifetime Advocacy Support Project. And we as parents sat down probably about 10 years ago thinking the same thing that Ralph was talking about, is what would happen to our children and the quality of life that they have and so on if the parents were not around. And we came up with the concept of needing an advocate, but not everyone can fund £400 a month. And I guess come the future, that might increase to sort of 450, 500, you know, as wages go up and so on. So we wanted a different model, and one that a charity can provide. And so we set up with some fundraising. We had coffee mornings and all sorts of stuff. And you probably appreciate you're not going to fund 2 or 3 advocates' wages and expenses and management with a few coffee mornings. It's just not sustainable. And also we needed to ensure we had a fundraising source that could carry on after the parents themselves had gone away, passed on. Because if the purpose of the project is to ensure that the children are looked after when the parents have gone, the fundraising source needs to carry on without any input whatsoever from the parents. And so we started off, and I was fortunate, I was able to retire early and set up a charity shop. And I'm going to share you some of that experience. But before I do that, you need to consider, if you are thinking of setting up a group along these lines, or you know people who might be thinking of setting up a group, I think there's a couple of key things to consider. One is, what is the funding source that will maintain the cost of the advocate or advocates, depending on the size of your group? Because you could, you know, tap into, you know, Virgin's Just Giving and crowdfunding and marathon running and all that sort of stuff and create a fund. But again, think about how that could be maintained when the parents are no longer around. So someone who's dedicated to creating that ongoing source of finance. And secondly, to ensure that that is providing for the project. Now, our parents, we have within the first project, CLASP project, we have about 20, I think we started with 28 families. 30 odd members, 28 families. As Ralph mentioned, some of those have unfortunately passed on themselves. So we're probably down to about 26, 27 members now. And so what we're trying to achieve is ensuring that they are looked after. So I'm going to share my screen now. Here we go. Doobie, 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 doobie. And the PowerPoint comes up. Here we go, and we're going to help. Where's this slideshow? Slideshow, play from start. Here we go. Can you see that? Put your hands up if you can. Fantastic. Right, so I started off actually looking around our local community area and looked for empty shops. This was about sort of 7 or 8 years ago. And I found 13 empty shops. I went to the land registry and found out the names of the owners of those shops. And I contacted them by letter because the land registry gives you the address. I didn't go through the agency because they also charge a commission and try to get you to pay for rent. And I asked the landlord if they would be prepared to let us use their shop premises, and we will pay the insurance on their empty premises. We will pay the rates on their empty premises as long as we didn't pay any rent. So we were not prepared to pay any rent. And this is, we set up what's known as a tenancy at will. So there's agreement to not pay rent, but to pay the insurance and pay the rates, which gave them the benefit that they didn't have to pay out on the insurance and the rates. And it gave them the extra benefit of knowing someone within the property looking after it, taking care of it, which meant they didn't need to keep visiting the place to see that it was safe and secure. So both parties had a win-win. And we also agreed that if they showed anybody around, we'd obviously let them in and be happy to move out if they agreed a contract with anybody. We had a week's notice. Now we expected to probably, this was in the August, we thought we'd be very lucky if we carried on to Christmas. And let me just say, we're still there. But we are not on a tenancy at will anymore because we ourselves wanted some surety and security of tenure. So we agreed a rent review, and now we've got a continued tenancy at this shop. So when we started, we had absolutely nothing. We put signs on the shop windows saying volunteers wanted, charity shop opening soon, stock wanted, and a little briefing of what we were about. And the community in the area absolutely flooded to our support. I'm probably not exaggerating much. After the first 3 or 4 months, aside from parents, we had about 30 volunteers from the community, which is phenomenal. And we set up what typically looks like a typical charity shop. We sold anything and anything. We sold clothes, shoes, DVDs, books, you name it. We sold everything. And that was our first shop. We've now moved on to our second shop, which we've named the Boutique. And what we realized after a while, we had one customer come in and said, we sold books, loads and loads of books. In fact, the back end of our shop was just books. And somebody said, oh, I like that bookcase. And how much is it? So I got a quick tot up of how much the books would have cost if someone bought the entire set of books on that bookcase. And it came to about £50. And I said, you can have the bookcase for 75, and they snapped it up. And it got me thinking, well, furniture is probably a good sale. And so we moved out all the clothing and all the accessories and the shoes and the belts and the hats and the handbags to our boutique shop. And if you look at the branding of that shop, the way the word Clasp is set out, it's very different to the first branding. And so customers didn't know the difference. They didn't realize it was the same shop. And we got customers in one shop that never visited the other, and vice versa. And it got us thinking about branding. And that's something to bear in mind as a longer term project, is to what is the image that your shop portrays, because we do not comply with the typical charity shop anymore. We view ourselves as a retail outlet raising money for charity. And so I often joke and say, if you have 5 Ferraris, we are a car showroom. So you have to be flexible enough to think about how money can be raised effectively. And we found the furniture shop actually raised more money than the clothes. So the clothes shop, or boutique as we call it, also sells furniture. And as you can see, we've got a picture here. We have sofas, we have tables and chairs and so on. And it really does not look like your typical charity shop. We try to make it look like a living room. So you've got your sofas, your dining tables, and your artwork on the wall, and your coffee tables and so on. And it looks really, really attractive. But that's just the retail
Sorry
shop.
to interrupt, just to let you know, we've only got 17 minutes left.
Okay, I've got 8 minutes, 55 seconds on my clock. I'm going for the 9 minutes.
Go for it. Sorry, I was just giving you a time warning.
No worries. Okay. finally, during the first lockdown, we set up a website. And in addition to the website, we've gone to clasponline.co.uk, that's our website. And we've also gone onto Instagram. So we're using social media, we're using the website to generate volunteers, to generate our shop revenue, as well as eBay. So in terms of fundraising, think of all the modern ways that can generate that income. But there's one key important factor here, is that if you're starting to set up a retail outlet, you need to have commitment of people to give that time. It's not something that will happen overnight. We are an overnight success that's taken 7 or 8 years to build up. Now, if anyone wants any assistance in how to do this, I suggest you go on to clasponline.co.uk and you've got an opportunity to book a speaker, and Ralph and or myself will be more than happy to come and talk to you on the phone, through Zoom, or when we're allowed in real life. Although I'm not traveling to Liverpool. Thank you very much. I'll stop sharing it.
Thank you so much, Peter.
And back to you, Kelly.
I'm just gonna replace me. Hello, everybody. I mean, I think, you know, it's so fascinating hearing both models and just how entrepreneurial you both are in making it happen. And just, I am constantly inspired by your generation and what you've done for your children. I'm going to try and be brief so that we can leave some time to answer some questions and open it up to everybody. But I come from a large family of 5. I'm the middle child, which hopefully makes me the balanced one. But my eldest sister, Jemima, has profound and multiple learning disabilities, was born that way. By the time I was born, she was living in a care home. So every weekend we'd go and visit her in Portsmouth. We lived in London. And I think our parents never expected or wanted us to take on the responsibility of Jemima. In fact, they were extremely anxious about the fact that we might feel responsible for her and looking after her as they age. So that was why they joined support groups such as Kith and Kids. And as a child, I have such fond memories of going on some of the 2-to-1 events and meeting other people. And as a person, you know, having disability in Jemima in my life has kind of enlightened me in a way that I don't see in other people. But as I grew older, I became more active in Jemima's life outside of my parents. You know, I got a car and I could go and visit her by myself and take her out for the weekend. And I got a bit closer to seeing how she was looked after. And sometimes there were good bits and sometimes there were not so good bits. And it got me thinking, you know, I was about 5-10 years behind my parents, thinking like, what happens when my parents aren't here? And more importantly, God, what happens to those people in Jemima's home who I know don't have any siblings, or they have a sibling, but I know that that sibling isn't active like me? Like what does happen? And so, because I was having those thought patterns and starting to have my own family, I kind of was looking at life through a different lens. And so becoming a member on the committee for class felt like a quite natural step for me. I wasn't quite sure what it would involve. And they were very kind and initially invited me to join on a sort of ad hoc basis so that I could fit it around work. I think I was heavily pregnant with a second child as well. And yeah, it's so nice to be able to sit next to them and look at what these parents are doing in order to provide this advocacy service. And in a sense, I've grown up and Jemima's always had an advocate. So I thought it was something that everybody had. And I think joining the committee has made me realise, wow, how special this is, and why can't there be more groups like this? So Jemima's advocate, Sarah, kind of aims to visit Jemima every 6 weeks. We're lucky, her care home's super receptive to Jemima, and they allow her to join. I think everybody has different setups. We have a quarterly circle meeting, and Sarah is very much included in that alongside the house manager, her key worker, myself and my parents. Sarah's attended meetings with specialists, and I think the value of that for us is that Sarah has the experience and knowledge of other care homes and other issues, and seeing what might be on the horizon that potentially we can't see. She also takes Jemima out. So Jemima has this relationship with somebody who, yes, it's a paid advocate, but she's a long-time person who is a friend, and it's about forming that relationship. And so the people in the care home know that Jemima has this other person that comes into her life, and it's not just her family. And again, always thinking about what about the families that don't have siblings and a parent passes away? Like, how much more important is that service then? And another thing, I don't want to talk too long, I want to let you guys speak as well, but I think, you know, as my parents are aging, I'm slowly catching up with all of the conversations that were happening with Luke. You know, how does it all work? Getting my head into it, all the things that my parents didn't want me to do, I want to do. I want to understand it and the changing landscapes. But actually, you know, when my parents aren't there and they're not able to make those decisions anymore, Sarah will be so useful to me because she'll have that wealth of experience that I might not feel as confident in. So there are so many positive reasons for doing it, and I think the challenges is how can we reach out to other siblings. In class, we're quite lucky, very recently we've had 2 other siblings join, and I think, you know, life post-COVID has enabled some of that to happen as well, because we're meeting over Zoom. Before it was always an in-person meeting, and I think that is something that, you know, will continue. It allows other people to join and contribute in ways that didn't happen before, and that will be something that continues. So perhaps, you know, moving to more a digital format will help other people to join. And also, if people don't have siblings, or there aren't siblings that don't want to be there, that's fine, but how else can we get people involved? Perhaps, you know, we need to look outside and beyond at people who want to join the charity and have an interest. And it's about creating a group that can function without specific individuals, but rather roles, and kind of moving towards a model like that. So I think that's enough of me talking. I'm going to add Peter and Ralph to the chat here so you can see all of us.
There's a possibility that they can use either Ralph or myself, or if anyone does set up a group, to include us in their Zoom discussions and just join it to help formulate some of their initial policies. We can think through things that help with our experience.
Yeah, at least we can be in a position to point out the pitfalls that we've seen and how we've got around them.
So I've picked out one question. Thank you very kindly for putting the big capital Q at the start, that helped. Is it considered a legitimate expense if the person in receipt of benefit spends some of their benefit to contribute to the £400 a month? So Ralph, this one's for you. Does the advocacy cease if the parent dies or can no longer afford the monthly contribution?
That's 2 questions. Okay, the first one. Is it considered a legitimate expense? Definitely yes. My £400 a month comes actually from benefits of my daughter. She pays for herself. And I did actually take advice as to whether she was able to do it. And I was told by my solicitor that definitely it is a legitimate expense. It is in her best interest and it's for her benefit. So have no concern. The £400 a month, if I may say, is just a number. It happens to be that that's what Reserve Power is charging its own members. But that gives 4 and a bit hours of time each week. If you couldn't afford the £400, you could set up a group to say £200 and have 2.5 hours of time each week. It's just a number. I've forgotten what the other question was, sorry.
And then the second part was, does the advocacy cease if the parents die or can no longer afford the monthly contribution?
We make recommendation that parents set up a trust fund to enable the fees to be continually paid. So if they die, then sufficient money has been left to continue paying the fees and the service continues. Unfortunately, we're not a charity. We all pay the same amount of contribution, and it would be very unreasonable to expect the remaining families to pick up the tab for the one that unfortunately has lost their parents.
So I guess if the member is paying for their own service through their benefits will continue. Therefore,
yeah, that's fine. But if it's not being paid that way, then fine. we would actually have to cease. Wouldn't happen overnight. It would go on for a few months or an hour to allow families or the remainder of the family to try and make other arrangements. But yes, it would cease.
Thank you. And then I've had a new question come in. Do the advocates have the specialist training, i.e. IMHA, IMCA, Care Act?
No. Pure and simple, no. What they have is empathy, a level of efficiency, a level of knowledge, and the desire to do the best they can for, I'll use the word clients, I hate it, their clients. I have yet to find out how anybody can become an IMCA. I have made many investigations into how to become an IMCA. And all I get told is that you become an IMCA by becoming an IMCA. So,
Peter, did you want to add something?
Yeah, I think Luke mentioned, did he say that for credibilism? I don't know whether it is.
Yeah, credibility is maybe some, yeah.
Yeah, I'm obviously a parent of a disabled, my daughter's disabled. And if we as parents say she needs 12 hours care in the community in addition to her other packages, the local authority sort of ignore us.
Yep.
But the advocate says the same thing because they're speaking on behalf of my daughter. It happens. So credibility comes from the title advocate. And our advocate, who's actually here, Gulay, gives a wave, sits in on some of the social care meetings, sits in on the care provider meetings. She's on the WhatsApp group, so she's got intimate relationship with what's going on in the home and how Chrissy's adapting to things and performing. And she can speak for Chrissy, and she does speak for Chrissy.
Yeah, but the point of the question was, are our advocates sufficiently recognised by the authorities, because they are not IMCAs, they're not an independent advocate under the Care Act or under the Health Act.
I think that to be open and honest and transparent here, the same advocate has very positive experiences in some homes and very negative experience in other homes.
And would be the same if it was an IMCA or not.
Exactly. Yeah.
I think that's the challenge, you know, as I've joined the group at CLASP, you know, talking about how do the advocates access people, and you know, we you know, you try the letter-headed paper and all those different approaches, but some people are just very cautious and worried that they're under attack, and I think that goes back to what both of you were saying, that it's about relationship building. And sometimes as a parent, you know, I have parents who even when they were together and they're now not together, with the polar, you know, my mum would always want to agree with everything with the staff because she just wants them to know that she's supporting them, and my dad wants to push and make sure that, you know, that nothing's being mollycoddled and it's not all about risk assessments, and they polarize each other even more. And as siblings, I think the care home were quite glad as we got older because we could kind of mediate a little bit, but also that's what the advocate can do as well, you know, because again, I'm still emotionally involved. So having somebody who's invested, but not clouded necessarily by as much emotion and has that experience of relationships is really important.
Does Gulay want to share anything? I don't really got any more questions, but she could share her experience there.
Definitely. Gulay, can you unmute?
There we go. Hello. Hi. So like Peter said, I'm an advocate for CLASP, one of the advocates. Sarah is my manager. Most of the advocate, well, I say most of it, it's only two of us, but Sarah has a background from day centres, I believe. She has had a lot of experience in this field with members with autism, learning disabilities, and so on. I myself have been with CLASP, it will be 4 years this year. But I've been in this field for nearly 20 years, not as an advocate, but I have worked as a support worker in many homes around Haringey for a well-known charity. So it really does help when I go into care homes, what I know what to look out for because I used to work in one. Like there's been times where there's incidents have happened, and when I'm saying to them, well, can I please see the incident report, they're looking at me like, how do you know about incident reports? You know, there's been times where I've, going back to what Peter was saying, where a parent can talk, they don't listen. I walk into a room, and as soon as I start talking about, well, you know, their health will deteriorate like this, and, you know, it's against their human rights, and all of a sudden, the whole meeting just kind of changes energy. And I have been in a room where parents are actually being really, like, they're being spoken to really patronizing by the social services or the NHS staff. I had one parent who was literally in tears because she felt like the way the nurse was talking to her, it was almost, mental health was talking to her, was almost like, well, you know, we need to get you off the list because of this, because of that. And it was just really patronizing. So I had to jump in and said, you know, is it okay if the mum takes 5 minutes break and I'd like to carry on? And I did. And in the end, they had to apologize to the mum because she wasn't abandoning her child. She was just asking for rightfully, you know, what should have been really provided for her. You know, they've had their child for 30 years in their house, did all their care for them. So I tried to explain to them, if this child, when she was a child, if she was given into care, the amount of money that would have been paid for her care, but this mum and dad have decided to look after their child at home, and now now they're being shouted at or being spoken down to, and there was no need for that. So thank God we ended up having a positive meeting in the end, where we, you know, carried on staying on their list rather than just being taken off and have to start the whole process again. Is there any questions? I'm so sorry, I feel like I could just go on.
I mean, I think it's really important that, you know, you're there for the grown-up or the individual as well as the families. And I think there's, you know, it's a very complex relationship because you're interacting with lots of people and kind of the glue in a sense, and helping to detect problems.
And what's beautiful as well, like what you guys were saying earlier, if the parents are no longer around, they still get to see us. Some of my members who are nonverbal, or they can say few words, when they see me, straight away it'll be mummy, daddy, as in they're connecting me. They know that I'm connected to mum and dad because mum and dad introduced me to them when I first started. So even though they can't express themselves properly, they can still use certain words their families would recognize, and they're basically connecting me. They know, we know that it's our mum and dad or our siblings that have sent you. And that's a really nice feeling, knowing that family's still looking out for them, you know?
Yeah, but
breakout rooms being closed, guys. We're going to get sucked away. Did you want to say one more thing, Ralph?
Yeah, I'm just saying that to Gulai, that relationship that she's developing and has developed with the people she's working with has enabled her to do her job, because she has made that relationship. She can understand so much in depth about the needs of that particular person.
Definitely, definitely.
I'm just going to add into the CLASP and Reserve Powers web addresses. So if you do want to speak to anybody or ask them advice, as Peter said, you can contact us. And I think as well at the end, I'll share the details too.
There's a whole range of questions that have been asked there. Can we perhaps answer them and share them on an email coming out at the end? I don't know.
Yes, I think I'll try and I tried to copy out most of the questions. If I didn't,
when you leave the room, when you leave the meeting, you can save the.
There you go. I've clicked save chat now.
Yeah.
Right, I've got it. All right. Thank you ever so much, everybody. And I'll see you.
Okay, have you got me then? Okay, speaker view. Still, so I'm struggling with this, I'm afraid.
You're muted.
You're muted, Stuart.
I've unmuted.
Right, now you're unmuted.
Yes, we can hear you now.
Okay, right. I'll go on to speaker view then. Right. I'm having trouble with this. Never mind. It's good because I don't have any overheads. So, right, I've been asked to put the proposed closure of Ravenswood in the context of how services have been developed in England over the last century. And I'll try and show today that services for people with a learning disability in England have developed in two quite different traditions, and how the proposal to close Ravenswood represents a conflict between these traditions. So the first and most dominant tradition began with the mental handicap hospitals, which started as self-sustaining colonies designed to segregate people with a learning disability from the moral risks of urban society, as was seen there. This was part of the drive for eugenics in the early part of the last century and the associated fear of the deterioration of the race. This model was increasingly challenged after the Second World War by the discrediting of eugenics, but also by a series of appalling hospital scandals, starting with the Ely Hospital Inquiry in 1969, a hospital where patients were seen scavenging in bins because they were so underfed in the hospital. The series of these scandals generated a kind of evangelical movement to close mental handicap hospitals and resettle people with a learning disability into as close a life as that lived by the rest of us. And the resultant residential ordinary life model, as it was called, was the small staffed home, usually converted from an ordinary suburban house in which 3 or 4 residents had tenancy rights with support provided by a care agency and day activities in separate facilities. Part of this evangelical movement was a distrust of specialised health services and opposition to larger communities for people with a learning disability, particularly if they're in rural settings. This is because both were associated with the old hospitals. Now, although this evangelical movement has largely succeeded in terms of accommodation, the small staffed home has become the standard type of service for residential care for people with a learning disability. The life of most people with a learning disability remains far from ordinary. Less than 1 in 5 are in employment, and this is mainly in part-time and low-paid work. People with a learning disability continue to have limited opportunities to form and sustain personal relationships, whether intimate or friendly. Loneliness, combined with the other disadvantages suffered by people with a learning disability, may account for their high rates of mental disorders. People with a learning disability are also at greater risk than the rest of the population of being the victims of violent and sexual victimization and offending, and this is considerably increased when they also have a mental disorder. Indeed, people with a learning disability express concern at their own vulnerability, and that, of course, is shared by their parents. People with a learning disability have a significantly lower life expectancy. That's a reduction of 13 years for males and 20 years for women. And the most common reasons for premature death, according to the 2013 confidential inquiry, were, and I quote, delays or problems with diagnosis or treatment, and problems with identifying needs and providing appropriate care in response to changing needs. In other words, they're service problems that mainly account for this reduced life expectancy. Okay. The second tradition of services for people with a learning disability is the intentional community, the minority tradition. And intentional communities were mainly set up by families of people with a learning disability from the 1930s onwards. These also had a clear moral purpose. One of the first was the Campiel community, established by Jewish refugees from Austria, whose commitment to embracing all people, irrespective of disability, religion, or nationality, was an explicit rejection of Nazi policies of enforced uniformity and the mass murder of disabled people in the name of eugenics. Families of people with a learning disability were particularly concerned to provide a homely community in which their adult children could lead stimulating and sociable lives in personal safety. These two traditions of care have developed in quite separate ways. Very few people with a learning disability were resettled from hospital to intentional communities, and there have been only limited transfers of staff and residents between the two traditions. Almost all academic research has looked at small staffed homes and has been heavily influenced by what I call this evangelical movement. This has led to a blindness to the limitations of the resulting services and a reluctance to compare the quality of life among residents in a small staffed home with those who live in intentional communities. So we can only really draw on one large comparative study in Britain and a smaller study in the Republic of Ireland. Fortunately, both studies were thorough pieces of research. The first was completed by a team led by Professor Eric Emerson in 1999 and looked at 3 types of accommodation: selected not because they were typical, but because they were seen as examples of best practice. The first type included 3 intentional communities, which the study calls village communities, with a sample of 86 long-term residents. The second type of accommodation were 5 NHS residential campuses, with a sample of 133 long-term residents. These were redeveloped NHS hospital sites in which the main buildings had been replaced by smaller housing units, often clustered, managed by the NHS and usually staffed by nurses transferred from the hospital they replaced. Finally, the third type comprised 10 dispersed housing schemes with a sample of 281 long-term residents. So there's a combined sample of 400, which makes this a very large study for research in learning disability. The researchers found that the residents in the 3 samples had similar characteristics, but there were significant variations in the quality of life of residents in the different types of accommodation. The most homely accommodation was found in the village communities and in dispersed housing schemes. Village communities were the most likely of the 3 categories of accommodation to involve residents in case planning and to have defined procedures for planning and implementing support for residents. Their plans placed particular emphasis on acquiring educational and vocational skills. NHS residential campuses were found to have the most institutional practices, in other words, the most rigid and conformist institutional practices, with village communities and dispersed housing the least. Residents in village communities were those most likely to have regular health checks and sight and hearing checks, although residents in the NHS residential campuses were more likely than others to be on regular antipsychotic medication. And the interesting thing is, they're more likely to be on antipsychotic medication even when you control the varying levels of challenging behaviour between the 3 different types of residents. Residents in village communities were more likely to see a social worker and therapy services, while those in the NHS residential campuses were more likely to see psychiatrists and psychologists. So this study found that dispersed housing in village communities offered a better quality of care and quality of life than NHS residential campuses. Dispersed housing in village communities, however, offered distinctive patterns of benefits, with dispersed housing providing more leisure activities and contacts with non-disabled people, while village communities provided more contacts with their families, more hours of activity, and greater personal safety. So in conclusion, Professor Emerson and his colleagues said that, and I quote, "Given that dispersed housing schemes and village communities appear to be associated with different patterns of benefit, people with intellectual disabilities should be free to choose between these 2 options." These results were confirmed by the smaller Irish study, completed 10 years later. Glass of water, sorry. The results of these studies show that the size of a residence and its location does not by itself determine the quality of life of people with a learning disability that live within them. A subsequent research study led by Professor Julie Beadle-Brown indicates that a more important factor in maintaining quality of life is the ethos and day-to-day organisation of a residence. It found that a high quality of care occurs where staff regard residents positively as members of a common but diverse humanity, and where their relationships with their clientele was, quote, characterised by warm feelings, which for many extended to a deep emotional bond. I don't think those conclusions are going to be very surprising to parents of adult children in residential care. These research results and the ensuing recommendations of Professor Emerson proved unwelcome to the evangelists for small staffed homes, who, like most evangelists, see the world as a simple conflict between good and evil. One particularly misleading study complained that evidence of the wide variation in outcomes between small staffed homes might, quote, threaten the consensus supporting deinstitutionalisation and community living policies by removing the evidence that community services are better for everyone. In other words, you start with conclusion, find the evidence and adopt the evidence to get that conclusion. The study also suppressed the evidence of the higher quality of life in institutional communities by grouping this data with that from mental handicap hospitals, nursing homes, and hospital-based housing clusters under the heading large congregate settings. In other words, a very disparate group of institutions were grouped together under this title, congregate settings, as a way of evening out the advantages that intentional communities had when the data was studied. What is most striking, however, is that this and many other similar studies, is a lack of interest in where people with a learning disability themselves choose to live. When I raise these issues with researchers at conferences, when I was employed as an academic, I was usually assured that it didn't matter because people with a learning disability will be happy wherever they are, wherever they're placed. So you didn't need to actually find out what they wanted or what they preferred. There's been very little research on the housing preferences of people with a learning disability. For one study I found of older people with a learning disability, found they preferred models of housing that provide an opportunity, quote, to live in close proximity to their peers and in large groups in the community, rather than in small dispersed community housing. It's probable, however, that people with a learning disability, just like the general population, do not all wish to live in the same way. An increasing number of people in the general population now choose to live in gated estates and retirement villages. There is also a growing demand for housing in the countryside. In other words, there are many different ways in which people choose to lead an ordinary life. There's not just one way of life. The right of disabled people to choose their place of residence is recognised by Article 19 of the United Nations Convention on the Rights of Disabled People. This requires public agencies to ensure that a diverse range of residential provision is available for people with a learning disability and to give priority to their preferences when they assess, commission, fund and regulate residential support. Nevertheless, this choice has usually been denied to people with a learning disability. The promotion by some public authorities and academics of just one type of residence for all people with a learning disability can be compared with the aims of reformers in the early 20th century who believed that mental handicap hospitals were the only appropriate accommodation for this group of people. In both cases, the wishes of people with a learning disability and their families were discounted. This form of authoritarian social engineering was common in the 19th and much of the 20th centuries for populations or objects of social concern, from slum dwellers to people with mental disorders. To conclude, there's a strong case from the evidence for maintaining intentional communities for people with a learning disability, both because they provide a high quality of life with distinctive patterns of benefits, because they provide a real choice of accommodation, and also because it's wrong to disrupt people's lives simply because the choices they make are considered by others to be a dated model of care which is no longer supported by national policy. Thank you.
Thank you so much, Stuart. That really does fill in all the bits and pieces most of us was unaware about. I've got a question. Is it possible to have a full reference for the Julian Bedell Brown study? Is that possible to do, Stuart?
I can not over the, what I will do is, yeah, I can send that.
Okay.
I've got a copy of my talk, which I can circulate, but I can expand it in a couple of weeks' time to include the references.
Right. We have recorded all this, as you well know, so people will be able to get a recording of everything if they're asking. I want to ask Tracy now if she would be willing to explain the issues and problems. Can we unmute Tracy? To explain the problems, in fact, that we are having at Ravenswood as it relates to the organisation that runs at Norwood. And after Tracy, we're going to ask Kate to throw in anything she can into the mix to help try to sort out the problem. So Tracy, we're trying to open you up. Can you unmute, Tracy? Yes, you're there.
Hear me. So would you like me to give a little bit of background about Ravenswood?
Absolutely.
Okay. Hello, everyone. My name's Tracy Morrell. I'm the mum of a 29-year-old young man with multiple and complex needs who's lived at Ravenswood Village for the past 12 years. Ravenswood was established in 1953 by 3 Jewish and 1 non-Jewish family to provide education and care for their children and others with learning disabilities. But no matter the background, beliefs or abilities, it has always been open to anyone with learning disabilities. It's now run by Norwood, a Jewish charity. It's a unique community located in a rural setting, 120 acres of green space, peaceful, safe, close to nature, and yet only a few minutes walk across the golf course into Crowthorne. There are 96 residents with learning disabilities living in the village. It employs approximately 400 people from the local community. All the staff are dedicated and very well trained. The residents live in 12 registered care homes. There is one home which specializes in autism and another in more complex needs amongst them. And many of the residents have lived there since they were children, because there used to be a school on the site. The village offers an extensive lifelong learning program, and a full range of complementary services are on site, including riding, carriage driving, hydrotherapy, rebound therapy, aromatherapy, music therapy. It has a state-of-the-art sensory facility, and some of the individual homes have sensory facilities as well. A cafe where residents can meet, art workshops, and a sensory garden. And I've probably missed other things that it has. In April 2021, families and staff were sent a letter by Norwood claiming that the current model of care is outdated, and it no longer is supported by national policy, and also that the village is no longer viable. In our view, the Families Association, it's unviable because Norwood has been running it down over the past 10 years and not advertised the provision to local authorities. So the number of residents has obviously declined. CQC reports for all of the homes were good, and one was actually outstanding. We've spoken to 5 local authorities who would not have a problem funding provision at Ravenswood if it suited the person's needs. Yet Norwood's narrative to families has not changed, and they're still claiming the care model to be outdated. And the location is, in their view, isolated. And that is the reason why local authorities are not keen to commission these services. We, as the Families Association, have seen no evidence to suggest that the local authorities will not send people to Ravenswood, and believe that settings like Ravenswood Village are specifically approved for disabled people. If we look at the white paper called Valuing People, a 12-week consultation process has been announced by Norwood to determine the future of the village. And at the end of that consultation, we are told that it will be up to the Board of Trustees to make a decision about its future by the autumn of 2021. Families and staff were told of only 2 very negative options for the village. One, that Norwood would look for an alternative provider, and 2, they are the closure of the village and the relocation of the residents to alternative provision. Obviously, families were distraught, having been promised lifelong care by Norwood. The whole thing was done in a very underhand, insensitive way by them, and it very much feels like families have been given a fait accompli. Luckily, we have a very active Families Association, with many families now joining us as a result of this. And there is a lot of knowledge and expertise amongst those families. So we've put our heads together, and one of the families produced an evidence-based submission disproving the claims made by Norwood. And we continue to try to find a channel for discussion with them to look at all the options for the village. We agree completely with other speakers that one model of care does not fit all. It's about meeting the needs of the person and choice. I know from my research 12 years ago, when my son moved to Ravenswood, that there was and still is, I believe, a national shortage of places like Ravenswood for people with autism and complex needs. Ravenswood is a community within a community, a place where the residents lead a happy and fulfilling life, close to nature, enjoying as much independence as their disability permits. It is the perfect home for my son, Harry, whose needs are multiple and complex. It offers a holistic person-centered approach to care and provides him and the other residents with the best possible quality of life. He is able to access the wider community whenever and as often as he wishes, and the same applies to all the residents. He and his flatmates, all of whom have multiple and complex needs, go cycling, sailing in the summer, skiing to the indoor ski centre, the cinema, theatre, on holiday, even as far as Disneyland in Paris. Whatever they enjoy doing, it is made possible by the team at Ravenswood Village. Many of the Jewish residents have even been on cycling repatriation holidays to Israel. If this sounds like the sort of provision you would wish for your loved one, please get in touch with us at hello@friendsofravenswood.com. Unfortunately, Norwood have removed any mention of Ravenswood from their website. Is it any wonder that the numbers are dwindling? Because nobody knows we exist. Thank you.
Thank you, Tracy. Yes, I think you've really explained the whole situation quite clearly. I mean, all the people watching this, and I know there are many people from Ravenswood, but there are many others. I want them to prepare themselves for the picket line to join us eventually, because we never know where this might end up. But Kate, you might be able to throw in some information which would help us in the actual fight we are having. So Kate Searle, over to you.
Thank you. Thank you for asking me to join you, and thank you, Tracy and Stuart, for wonderful presentations. So the difficulty that you have with Ravenswood is one that was really picked up by Luke Clements, where he's talking about dogma and about policy. And I've read the submissions that were put together by one of the family members of a resident at Ravenswood, which are really very, very skilled. And he hits the nail on the head in this way. So what we are hearing and what Ravenswood themselves have said, because they would like, for whatever reason, I don't know things well enough to know whether it's really about money or really about policy or really about dogma, but let's imagine it's a little bit of all three. Is it Professor Jacobson, I think, Morris, who's been talking to you from Ravenswood? Her view is that Ravenswood presents an outdated model of care, and this is also referred to as a closed culture. And the CQC, the Care Quality Commission, they refer to this type of village setting, which are quite few and far between now, but there are some, and they are going strong still. The CQC refer to them as congregate settings, and I don't love any of this language really. The congregate setting is quite a strange language, and the CQC tried to prevent an organisation called Centurion Health from expanding the village farm community that they had by opening a second accommodation for adults with learning disabilities. By basically strong arm tactics, the CQC refused to register the proposals for the expansion, and the people at Centurion took this to the first tier tribunal, and they were successful in that first tier tribunal in defeating the allegations made by CQC that the village community or the closed community or the intentional community is outdated. And as the other speakers have said, this is all about what works for the individual and what is in the individual's best interest. That is the law that we're looking at. So what works for them is public law. That's about their needs and their preferences and how those needs are met. And provided that Ravenswood stays open, there is no reason why other local authorities or privately funded individuals should not be using Ravenswood to meet the needs of their learning disabled or autistic relative, if it is the right setting for them. And quite often, I know somebody spoke earlier about sensory needs. I used to work with people with learning disabilities before I became a lawyer, and a number of my clients had sensory needs, and that actually meant very simple that they required a quiet setting that was rural rather than a city setting. And then I had other clients who preferred a city setting, but there should be choice. And my concern is that where a body starts issuing judgments about the service it runs itself by calling it outdated, we're going to end up with less choice. You don't need to hear me rehash what everybody said. What we need to talk about is what can be done about it. So there is a public law position, which is that I understand some of the residents at Ravenswood have been given what we call home for life promises. Yeah. So back whenever it was that they moved in, whether that was as a young person or as an adult, they were told that Ravenswood would be their home for life. And so where a home for life promise has been made, the courts, and when I talk about the court, I'm talking about the High Court of England and Wales. The High Court of England and Wales will work very hard to prevent that promise from being withdrawn. Okay. That doesn't mean that you will definitely succeed by running what we call a home for life promise argument, but it is certainly one that should be looked at alongside the Residents' Article 8 human rights. Okay, so these are two very strong public law arguments that are open to the Friends of Ravenswood as part of the consultation process, and perhaps after the consultation process, if you don't like what the outcome of that consultation is. We don't want to give away all of what your tactics are going to be, because we don't know if there's anybody that we don't want to be looking at this video and talking about where we're going. But you will have a right to consider, you'll have an option of considering litigation based either around the individual's Article 8 rights or the home for life promise. I'm going to just come back to that, because we would have to establish that Ravenswood is itself, the parent organisation, is in fact open to being judicially reviewed, by which I mean it is a private body, and normally we can only judicially review we can normally only judicially review public bodies, health, social services, government ministers, education, and etc. But where a private body has what we call public functioning arm and provides services that would normally be provided by health or social services, then we would spend time, and this is something that Luke Clements and his team at Leeds do all of the time, it's what community care lawyers do. You spend time looking at arguing that in fact it is possible to judicially review them, or to threaten them with judicially review against the closure, yeah, because the closure would be, as I say, a breach of the home for life promise and or a breach of the individual's Article 8 human rights. So we would need to do a little bit more work on that, but it's one of the options. The other thing that's really sat with me when I've been listening to the other speakers today, and when I was doing my preparation, I had a chat with Tracy and Morris about a month ago. This is how I've become aware of what's happening at Ravenswood, is the fact that this is a faith-based community, and I think this is also an important argument in your armoury of arguments. I do not think that we do terribly well in the UK at promoting care in a faith-based setting, where that faith-based setting is a need for the individual or a preference for the individual, and it could be either. Okay, so I think that is very important. And then if you look at what is unique about Ravenswood, it is that, and it is the setting, and it is the community. There's a lot going for it, but what you can't do, unfortunately, is you can't make local authorities place people there if, for whatever reason, we find that Ravenswood are actively not recruiting, as it were. They're actively not inviting people in. It's going to be difficult for you to do anything about that. And then you hit a problem, because that, if they're not getting new members to join, new residents to join, then that will make it easier for them to argue about financial inviability. So there are a few issues there. The other thing I wanted to briefly touch on was the point about best interests. So Luke told us about the case that was brought by Ealing to bring the young man back from an intentional community that he lived in, that he was happy in. And it was a case that was dealt with by Lord Justice Jackson, who's always a good judge for quotes, and being really quite brave with his decisions. We don't necessarily say that about all of the judges who hear these public law matters. That was a best interest argument, and the question there for the adult was whether it was in his best interest to remain in what had become his home, even though it was, what Ealing said, an outdated model of care, or whether it was in his best interest to move to inner city supported living. And there was no doubt a really strong public purse argument that Ealing wanted to run, because it's much cheaper if somebody moves into supported living, partly because some of the charges for the supportive living come off the housing benefit budget instead of coming off the social care budget, okay? So that makes it cheaper for social services, and social services will always jump up and down and argue that they have a right to take their resources into account. Fortunately, Justice Jackson wasn't hearing any of that, and he wanted to look at what was in this young man's best interests. And and his decision was that it was in the young man's best interest to remain where he was. This is the home that had been promised to him for his life. Now, I don't know how far people have got in terms of whether there has been any best interest analysis, Tracy or Maurice, yet for the individuals living at Ravenswood. So that will follow after the consultation, I suppose. So there's going to be a system. They are obliged to consult. They must do that consultation properly. We can have a look at whether it's a proper consultation or not. If it's not a proper consultation, you can challenge the failures in the consultation, and then they would have to start consulting again. So they have to do it right. But at the end of that, if they make a closure decision, you, as the families of those adults who lack mental capacity to take action for themselves and make decisions about their own health and welfare arrangements, are likely to have to consider litigation. So where best interests is very, very important, and I don't want to be negative, and I don't want to send any of you away from this session feeling a sense of dread, but the difficulty that we have with best interest being the answer, it was the answer in the case that Luke told us about, Ealing. Ealing only had one resident placed in that village community, and nobody was suggesting that the village community should be closed down. So that was a great case to take to the Court of Protection on a best interest analysis. The difficulty with Ravenswood is that if a decision is made to close Ravenswood, even if they're talking about phasing it and they'll take their time and it might be 2 years or 5 years or whatever, if that decision is made and that decision is not challenged, I'm afraid that best interest arguments in the Court of Protection are not going to be the salvation for this situation. And that is because the judge is only able to make a best interest decision for something that is an available option. And if a decision is made to close, then it will not be an available option, which means the best interest process is not going to come to the rescue. So I don't want to dwell on the negative, but I do have to just put that forward. I don't know if there's anything else you want me to say about public law or Article 8 human rights or Home for Life promises, but that's just a kind of a summary, an overview really of the issues that you need to look at. And in my experience, so as I said, I worked in with adults with learning disabilities long before I became a lawyer, so back in the late 1980s and early 1990s. And power of numbers is a very strong thing. So I'm not speaking now as a lawyer, I'm speaking as someone who in her own time has campaigned against the closure of services. And the power of working together is really forceful. In Sussex recently, there has been a closure of a service that managed the needs of a large number of adults with complex physical disabilities and also cognitive learning disabilities. And understandably, what happened as the date for the CQC tribunal came forward, it was a failing service, so I'm not comparing it to Ravenswood in that way. The service was failing and the service seemed unable to improve, and it had warnings. But equally, the CQC were absolutely determined, it seemed to me, to close that placement down. And you could imagine that parents and other relatives began to feel very nervous. and there was almost a divide and rule. The local authorities were all talking to individual families, and one by one those families took up the other options that were put forward to them for their adult child, because they were frightened by the idea of having nowhere to go. If you can, obviously you will make the decisions that are right for your adult child, but all I can say is there is safety and there is power in numbers, and I shall stop there. Is that okay?
That's lovely, Kate. Thank you so much. I wonder if anybody has a question to ask any of the previous three speakers, could you put it into the chat? And we can do it. I just wondered, because in fact the families are organised themselves from a range, I wonder if Jasmine, who's on there, could unmute herself and tell us what we're actually up to, if we can find her, so we can allow her to unmute. Where are you, Jasmine?
Hi.
Have you unmuted?
Yes, can you hear me okay?
Okay, lovely. Do you want to update us on what the activity that we're up to? In the meantime, if anybody has any questions, put it into the chat, please.
So we've got a number of activities happening. We've divided into a two-part strategy, is the best way I'll describe it. The first part is a positive campaign, working with Norwood in a positive way, assuming that we can have their support to try and convince them of the merits of the village. And the second part is the one we don't want to do, but one which, as Maureen said, we may have to do, which is a negative campaign, where we have to actually show the damage that Norwood has done through neglect. And that would involve going to, for example, the Charity Care Commission to show the examples that we have and the evidence that we've created. So that's part two. Although I've mentioned we don't want to do part two, as part of this initial stage, we are still preparing for that. So the first things we're doing in this stage are, first of all, to collect the evidence. So as Tracy mentioned, the Ravenswood has been taken off mentions online. It's not available to be found. I actually had a friend who works in the charity sector. I mentioned Ravenswood to her. She looked it up and couldn't find it online and thought that I must have had the name wrong. That's the extent to which Norwood has taken the visibility of Ravenswood down hugely. There's also been an analysis done by one of the families which showed the number of mentions online which Ravenswood had previously, and how over the years this has steadily declined. And it's really shocking, actually. But the point is there is evidence out there which we need to document now before Norwood have a chance to change anything. So Norwood may very well, for example, start putting things up about Ravenswood. I've noticed on their Facebook, they've started mentioning Norwood started mentioning Ravenswood a little bit more. I think we need to be really mindful of that. So that's first of all, it's getting ready for that negative campaign if we need to do it, but also it's proceeding with our positive campaign. So what that involves is sharing how amazing Ravenswood is, again, in an evidence-based way, but in terms of the unique facilities, the unique experiences which families have had.
1 minute, Jasmine, 1 minute to go.
Oh, sorry.
Before they take us all back, we'll all be shot back into the main hall.
Sorry, so just in summary, we are raising awareness, we are doing fundraising, we are gathering the troops, we're getting as many supporters as we can, we are getting ready for PR, we're speaking to reporters, we are going to have a press pack ready to go, and we're going to do a big campaign in a positive way.
Thank you so much. Can I just say one other thing? There's lots of people, both Kate and Tracy, is that it has been mentioned a few times on the chat that this is not just to do with Norwood and Ravenswood. It is the wider problem that exists right across the country as it relates to intentional communities. So this we're using as a case study, but of course the same thing applies across the country as a whole. Tracy and Kate want a quick word. Tracy.
No, did I put my hand up? No,
you did. Okay, you don't?
Actually, I did get, I was informed just recently, apparently the CQC have recently updated their ways of working and have put a renewed emphasis on culturally appropriate care.
Right, well done.
So, great. I was just going to quickly say this to Jasmine. Thank you. That's really brilliant to hear what you're all doing. I am concerned that Norwood, by deliberately taking Ravenswood out of the public domain, may be quite intentionally what's the word, maladministering the outcome of the consultation. That worries me, and it might be something, Maurice, that you want to have a chat with Luke about. Is that regarded as so unfair that they have stopped the level field being level, the playing field being level? Right. And if so, does that invalidate what's happening now, and do they have to start again? So make sure you've got your screenshots, make sure you can see exactly when they start changing things, because they will have a legal advisor or a team of legal advisors who will tell them how to get what they want, and you need to be ready to undo any of that.
Lovely. Stuart, is there anything you want to add?
No, just to say that I live in a village community. It's in Worcestershire. It's not a learning disabled village community, but we're not socially isolated. We have an intensive social life, and everybody wants to live there. People want to keep building houses in our village. So the idea that the normal life, the only life that's permitted, is to live in a suburban house in the suburbs of London, is quite wrong. There are lots of different ways of living your life, and they should be open to people with a learning disability, just as they are for the rest of us.
I've just read the Richard Osman novel, which is called The Thursday Murder Club, and that's set in a village community for older people, somewhere between Sussex and Kent border. And again, it's a very good novel to read, but it's all about community being so important. And it's the same thing that you're talking about, Stuart. It doesn't matter what the reason for the community is, it's your choice.
Okay, well, I've got a little thing up on saying I've got to close now. So I'm going to close now. We'll be going back to the main meeting, I think, and we'll all, and each of the chairs will say a few words about how their breakaway session went. Hey, are we all back now, Sophie?
Yes, looks like it.
We're all back in the room. Right, well, perhaps Samson, would you like to kick off on how yours, can you unmute yourself, Samson, and give the view of your particular breakout room and what happened?
Actually, we didn't, we sort of ran over time. We didn't have much time to field any questions. So what we were doing is just answering I was answering the questions by chat box. And as Mo was giving the slides, just giving a rundown of what we did. But unfortunately, we didn't get a chance to have the free-for-all type discussion to feedback, unfortunately.
Right, okay. So number two, which was number two, was in fact the advocacy, working with local authorities, which was Ron. Where are you, Ron?
Just here.
Can you unmute yourself? Well, you are unmuted, but we can't see you, Ron.
I'll try and be seen. I've got a bit of broadband issues, but let's see if I can sort that out for you. Okay.
Okay, Ron, how did yours go?
Well, it went well. There was a bit of learning to do about timings, but we've taken down some questions we didn't get round to, and we will make sure that they're answered as best we can in the feedback afterwards that goes out in the emails. I guess some of the key questions were, or the key areas were, the importance of getting to know the local authority, what they're about, their commissioning plan, key people and decision makers in the area that your family requires the care, and the fact that these relationships, particularly with learning disability cohorts, can be very, very long term. And so for a number of reasons, even our lawyer agreed and felt that it was best not to go legal for the sake of going legal. And we had some discussions about the importance of deputyship and the Mental Capacity Act. And I think those were the key areas, but we probably didn't get time to drill down into some of the individual approaches individual parents and families might make to establish a productive relationship around eligibility. We probably didn't.
Right, you've gone off, Ron. Have you finished?
Yeah.
So did Paul want to add anything to that? Is he still here, Paul? Is Paul still with us, Ron?
Yeah. I'm still.
Anything you want to add?
Yeah, I suppose I'd just like to not push back a little bit on what Luke said around about dogma. And I sort of feel, as an ex-local authority person, I mean, dogma is a point of view that's authoritative but without adequate grounds. And whilst I can recognise that some authorities, local health, might not have adequate grounds, I think it is also a little bit dismissive to sort of say that actually, they haven't got an authoritative view that is based on policy, is based on research, that's based on co-production and lived experience. So my 30 years as a social worker, going into policy, going into strategic commissioning, I certainly wouldn't want to still see the same services that when I entered into social care, and I would hope that they would still evolve and maximise people's independence and promote independence. And so I suppose I just want to push back that local authorities, I think, dogma is a strong word, and but I think we have to be fairly, respectful as to, policies come via council routes. It's a political body. Policies are agreed and voted on, and any member of the public can go to the committees where they're voted on. So, we can't completely dissociate ourselves from that body politic, which is a local authority. It's different in terms of NHS, I get that, but certainly in terms of local authority, we all have some responsibility to, to inform ourselves and to be part of that dialect. And actually, if you don't like the offer, be part of changing the offer. And certainly my experience in Nottinghamshire is lots of personalisation and lots of changes, which I actually feel for the better, were driven by people who had lived experience working collaboratively and actually having difficult conversations, but from difficult conversations came a better, more trusted route forward. So that's sort of just my little penny's worth.
Thank you so much, Paul. That was really an interesting position that you made there. Tilly, can you unmute yourself? Well, you are unmuted, I can see. How did your lot go?
We didn't have enough time, Morris.
I'm sorry about that.
We need more time. Yeah, I think there's so much there, isn't it? And trying to unpick it all is quite difficult. But we were talking about the two different models of having an advocate service. So one being privately funded and one being funded through a charity. And I think, what came out of the two different models is that funding them is an issue and something that constantly has to be looked at, and how you do that is going to be the focus of the group. The importance we talked about of having an advocate, not only for the person they're advocating for, but for family members and also care homes, and how it's really about relationships and how they can interact with the different areas and connect dots and diffuse, and with the experience of interacting with lots of different care homes, they can bring expertise and sometimes see something that's on the horizon that might not be there. We also talked about how you keep continuity there, so the issues that you have of people passing away, whether they're members or parents, and kind of bringing in, for want of a better word, fresh blood. So that could be a sibling, and lots of parents don't want to put that pressure on a sibling. You don't have to be there, obviously, but having that person. Then there, of course, there's families that don't have siblings. So how can we support families that don't have a sibling, or a sibling that doesn't want to be active? And again, what the advocate can do for that family for peace of mind is just really wonderful and important, and it gives them a relationship beyond family. Yeah, and I think everyone was kind of really passionate about how wonderful it is.
Well, thanks very much, Julie. That sounds like a great session. I'm sorry we didn't have more time, but we are going to circulate everybody on what issues they would like for us to do next. I think Ron is going to be sending something out to everybody, and if people reply to what he says, either to give ideas and try to expand on the things that we've discussed today, we'll be doing that. Anyway, the final grouping was the group that related to intentional communities and using a case study of Ravenswood. And of course, that particular issue is much wider than just Ravenswood itself. It applies right across the board, the ability of choice. But I'm going to ask, I'll ask Tracy if she would say just a few words on how she had a bit of shock there, and how she felt about how the session went, and perhaps Stuart will finish it off.
Yeah, you really put me on the spot there. I'm not prepared.
That's
No,
life.
It was an excellent session. I think we're all singing from the same song sheet. Basically, it's about what the person's needs and choice. These communities are right for some and not right for everyone. Yeah.
Lovely. Well, I mean, that was, and Stuart, anything from you? Stuart, anything from you to everybody?
Just to say that what the academic research confirms this, that intentional communities provide a good quality of life, as good as anywhere else, and better than many dispersed housing schemes. And I think the key issue is choice. We would expect to exercise that choice in our own lives. We've no right to move other people around just to meet some dogmatic concept of how they ought to live. What we should do is listen to them and their parents. And if they're happy where they are, don't disrupt their lives and make their lives a misery just because you've decided they are living in a so-called outdated model of care.
Thank you. I mean, somebody mentioned to me the other day is that when the letter was originally written to all the parents, they did what he called the Ratner option, right? They were saying that what they were doing was a load of crap. Would you like to take it over? Which I thought was a very, very interesting comment to have made. Anyway, we're going to end there, and I don't know where Sophie is, who we all owe Sophie. Where is she gone, Sophie? You there? There you are. Just want to thank Sophie for the amazing thing that it all worked, or seemed to all work. So impressed, so impressive. Thank you all so much. Thank you very much for operating it, and thanks for everybody for attending. And we look forward to having another event, perhaps in the autumn. Ron, you're making note in the autumn. We'll have another go with Lynn, who I haven't seen, is around somewhere, Lynn Brooks. Thank you all so much. See you again shortly. Thank you. Bye, everybody.
Bye.
Bye. Thanks, Maurice.